I am calling to order this regular meeting of council. First, I'd like to acknowledge that this meeting is taking place on the traditional territory of the Sanawas First Nation. First item on the agenda is adoption of the agenda. I'll just read the motion that the November 17, 2021 regular council meeting agenda be adopted as presented with additional information for item 9C, 9F, and 10A. I have a seconder for that. Second by Councillor Savage. Any discussion on the agenda? Okay, hearing none or seeing none, I will move to call in question. All those in favor and opposed? Okay, that is carried unanimously. Okay. All right, that takes us on to item 7 of our agenda. So we have the start of the consent agenda. So I'll just make the motion that the recommendations listed for items 7A to 7B in the consent agenda be approved. Do I have a seconder to that? Second by Councillor Savage. I will move to calling the question. All those in favor? Opposed? That's carried unanimously. Okay. All right. And for public input, do we have anybody registered this evening for public input? Seeing that we don't have anybody, we'll move on to item 9 of our agenda. Okay, under legislative matters, we have bylaw number 281. We have a motion on the floor. This is postponed from the September 8th, 2021 regular council meeting. And just for the viewership, I'll read the motion that the District of Lantzville zoning bylaw number 180/2020 amendment in parentheses 6935 Dickinson Road, bylaw number 281/2021 be given first and second reading. So it's already on the floor. Yeah, I'm just reading it for the. That is 9A. No worries. Okay, so it's on the floor. So I'll take a speakers list. So Councillor Savage and anybody else wishing to speak at this time.
Your Worship, Ronald Campbell.
Yes.
Sorry for the interruption. Were you advised that Jamie Wilson might be late tonight by 15 minutes or 10 to 15 minutes?
He's in the chambers as you speak.
Okay, he has showed up.
Okay. All right. So through to you, Councillor Savage.
Yes, thank you. With respect to this application, the problem with it is it's over doubling the density by rezoning, but the community is getting pretty well nothing in return. The community amenity contribution document lists the number of amenities we could get. 20B states parkland in excess of the 5% statutory minimum, and 20D states trails, walkways, pathways. But the only thing ever focused on is these paltry $3,000 per lot, and not for all the lots, just for those above the current zoning. This is in effect giving away free zoning lifts. It is representing only the developer, but not residents. Developers get all the profits, and residents get the negative of less nature, more traffic, more air pollution, and a more crowded community. We're far better off not rezoning this property at all and just letting the underlining zoning of the future study area be half-acre lots, which will preserve more private green space. There's nothing in it for the community to increase the density. 0.237 acre lots with yet more big single family houses is just what Lantzville doesn't need. It's the very definition of urban sprawl. It's the very definition of cookie cutter subdivisions, which the OCP opposes. So the whole idea in the OCP was to leave a base density of half-acre lots and only allow density increases for the purpose of benefiting the community. This is a 210% density increase. The property next door, we at least got some road improvements as well as the small 3,000 per extra lot. The OCP states clear as a bell, increasing zoning density on residential land should provide in return more than 5% parkland plus an amenity. The OCP and the residential land designation section states 5.2.7.1 for subdivisions, the gross development density of areas designated residential outside the village area is 5 units per hectare. That's 2 units per acre with municipal water and sewer services. And then 5.2.78 goes on to say, right after that, the district may apply a bonus density in residential areas without amendment to the OCP where the development plan includes parkland acceptable to the district in addition to the required 5% dedication and a community amenity contribution. It says an OCP amendment is not needed if these requirements are fulfilled. Well, I don't see these requirements as being fulfilled. So in my mind, an OCP amendment should be necessary. Once again, the OCP is being disregarded, just dismissed like an inconvenience. So why did the developer next door have to give more in amenities? That doesn't seem fair to me. There's also the water issue. All these free density increases are increasing the consumption of our valuable aquifers or forcing us to use Nanaimo water, which will service most of this proposal or some of it. So that is important because the whole theme of lowering water standards and Nanaimo water was to get it to those in need of better water. And it doesn't seem that way to me. It seems that it's just going for nothing but new development. And Nanaimo water will cost more, so all current water users will have to pay more. So in effect, they are subsidizing new development. In fact, our budget shows an increase in water user rates, partly due to using some Nanaimo water in the system next year. So those are my thoughts. I think it should be referred back to look into getting some proper
Councillor
amenities.
Savage,
Thank you.
it's your time. Additional speakers on the motion. Okay, hearing none, I will, I guess, go next. Yeah, obviously we've seen this one or before because it's already on the floor, and I'm not going to rehash my debate on it. You know, there's recommendations within the staff report with respect to this. The one thing I did come tonight with is an amendment, and I think the amendment would, I might actually speak to what Councillor Savage is alluding to, which is creating some equity between the two properties. So there's the Windley property that's already being granted subdivision, or not subdivision, sorry, the rezoning and OCP amendment. And part of that was doing some traffic calming. So I'll just go into my amendment now. So I'm going to propose the amendment as follows. And sorry, Director Coates, I could have probably emailed it to you, but I'll go slow. And further that, the final adoption of District of Lantzville zoning bylaw number 180, 2020. Amendment, open bracket, 6935 Dickinson Road, close bracket. Bylaw number 281, 2020. Be conditional to the registration of a covenant to install a permanent speed reader sign in the vicinity of Dickinson Road to the satisfaction of the Director of Public Works.
I
And
need
I
you to
can do it
repeat
again.
that, thank you.
Sure. We're from. Okay, and further that the final adoption of District of Lantzville zoning bylaw number 180/2020 amendment. And then 6935 Dickinson Road. Bylaw number 281/2020 be conditional to the registration of a covenant to install a permanent speed reader sign. So far, so good. Close.
So it's just the citation of the bylaw, is it? It's bylaw number 281?
Yeah, 281, yeah.
Okay.
And it's really just be conditional to the registration of a covenant to install a permanent speed reader sign in the vicinity of Dickinson Road.
A permanent speed reader sign?
Yeah, a permanent speed reader sign or board sign. To the satisfaction of the Director of Public Works.
In the vicinity of Dickinson Road?
Yes, to the satisfaction of the Director of Public Works.
So for clarity, the motion is to amend the motion on the floor by adding and further that the final adoption of District of Lantzville zoning bylaw number 180/2020 amendment 6935 Dickinson Road bylaw number 281/2021 be given first, sorry, be conditional. Final. So just a thought is that usually it's not that the final adoption is conditional on. It's usually that council not consider final adoption of the bylaw until a covenant has been registered. Because otherwise you don't have a definite date of when the adoption occurs. So usually anything where you're going to make it a condition before you'll consider adoption, it's usually phrased in that way.
Okay. So, yeah. if
So
you
it'd be
wanna
that
amend- yeah.
adoption of then citation not be considered until the registration of a covenant to install a permanent speed reader sign in the vicinity of Dickinson Road to the satisfaction of the Director of Public Works. And I'm not sure if the CAO or the director looked at this. Some things we can do by covenant, some things we can't. So if they're satisfied that this is something we can do by covenant.
Yeah, I did talk to the Director
Yeah.
of Planning about this.
Okay.
So, do you have a seconder to the motion? So second by Councillor Savage. So in terms of discussion, I'll just lead it off. So similar to the adjacent property, there's going to be increase in traffic spilling out onto Dickinson Road. And it's not a great stretch of road, lots of speeding on that section. And this is just to add to the another layer to the traffic calming in that section of Dickinson, going up or down the road. In this case, it'll probably serve to slow people down going down Dickinson, not necessarily up. But I think anything we can do to try and mitigate the impact of increased traffic flow and also to increase safety is warranted. And this, from what I understand, this proposed amendment or zoning amendment will create additional parcels. Those parcels are likely to go down the newly created road of the Windley development, and there's going to be increased traffic. So this is hopefully will address that and again make roads safer. So through to the seconder if you wish. And
Yes, thank you. Through to staff, does anyone on staff happen to know the cost of approximate cost of such a speeding reader?
Yeah, through the mayor to Councillor Savage, it's around $15,000.
Yep. So while I'll be supporting this, I think this is only a start. You know, when I see communities develop, the whole idea is to, you know, a development only happens once. So you make sure you put your community in good shape to make the most of that community and make the most of that development to benefit the community. And again, with the enormous amount of money involved with real estate these days and lots and so on, and the services that will be required from the community, it's important to get a fair return. And as I say, this is a 210% increase in density lift. So we're now getting, I think it was 15,000 plus another 15,000. That's only $30,000 compared to well over into the millions for profit from this. So at any rate, I'll certainly support this as a start. But I think our recent heavy rain event that happened showed that nature is a very valuable infrastructure for mitigating rain runoff. It helps with drainage, helps absorb the runoff. So wherever you can get nature, you want it. And we won't have a trail system if we keep going like this, getting zero public space in these developments like Sabrina Zero. We're not going to have a trail system at all. So while I'll support it, it's nowhere near enough. Thank you.
Okay, through to Director Coates.
I guess I'm more accustomed to seeing motions that provide conditions before council will consider adoption occurring, you know, at third. I'm just wondering if you would be interested in adding something, because otherwise it sounds as a little presumptive that it's going to be considered for adoption. And further, that if the bylaw proceeds past third reading, that before consideration of adoption, so that it's very clear that this is a motion to consider first two readings. So we still have public input, consideration of third reading before you.
Okay, yeah, thank you for the comment. So in terms of suggested amendment to that would be to.
And further that if the bylaw proceeds
To third reading?
yeah, to third reading.
Okay.
That consideration of adoption, or no, I guess we've already reworded that one, that proceeds past third reading. That adoption of the not be considered until registration of a covenant.
Yeah. So through to council, any objections to that? We can just do it through it's through unanimous consent. Okay, so there's no objections, so we'll go with the slightly altered wording to the amendment. And I see Director Young, you had your hand up. Did you?
Yeah, Mr. Mayor, I just wanted to say the resolution was fine the way it was. It's not presumptive. Council's in no way obligated to give third reading to the bylaw following the public hearing. If there's this condition that adoption be subject to registration of a covenant, council is in no way obligated to give third reading to the bylaw, so it's not presumptive in any way.
Okay, so just as a follow-up comment, the intent behind the amendment anyways was to not have this situation that we go to public hearing if that's the will of council, and then there's an amendment after the fact, and then we have to hold another public hearing. So it's to, and also not to have this recommendation go back to the applicant and then come back to council for again first and second reading. So it's to help try and facilitate the process along, if that is the will of council. So Councillor Gusbrook, you had your hand up.
Yes, thank you. Through the chair to staff, is it normal to have a permanent speed reading device installed on a community roadway?
Yes.
Okay. And through the chair to staff once again, I'm just trying to remember, the Windley subdivision is to the east of this subdivision, meaning it's uphill on Dickinson Road.
It's to the west of this subdivision.
To the west of the Windley subdivision.
Sorry, no, the Winley, through Mayor to Councillor Gesselbrock, the Winley subdivision is to the west of the subject property that's under consideration for rezoning.
Now, council, in approving the other subdivision, we'll call it the Windley subdivision, requested that the developer provide traffic calming, which I understand is some sort of median in Dickinson Road. Is that correct?
Through the Mayor to Councillor Gesselbrock, yes, it's a combination of a few different things. It's a center median. It's a concrete curb and gutter on the north side of Dickinson Road, and what are called transverse bars. So they're painted lines on the road in order to provide a visual that will slow traffic down.
Thank you. So, you know, this is a safety issue, and I certainly wouldn't be opposed to this, but I don't think this is the right time to make this amendment. I can see from the back and forth between staff and the mayor that perhaps this should have been vetted with staff ahead of time to get the kinks out. I think my preference would be to defeat this amendment. And if the underlying motion is going to be passed, which is only first and second reading, that the mayor, or in fact anybody, can bring an amendment back to deal with this. I just don't think this is the right time, but I will, through the chair to staff, am I correct in that assumption? Or would the mover be not able to bring back this amendment after first and second reading?
Yeah, through the mayor to Councillor Gesselbrock, I don't think I quite understand the question. The motion on the floor is to give first and second readings to the bylaw and further to require the registration of the covenant. This is if council wants to impose covenant requirements, now would be the time to do that. As per the staff report, the developer has already agreed to and is already registering a covenant to secure the community amenity contribution of $3,000 per parcel. The benefit of requiring this now and having the covenant drafted is that the public will have the benefit of seeing that requirement and covenant prior to the public hearing.
Thank you. All right, then, yeah, it's a safety issue. It's a benefit. Dickinson is dangerous at this point. I know that we have in our budget for next year to redo Dickinson Road. So there'll be other changes, but at this point, I think I can go along with this amendment.
Additional speakers? Okay, first time speakers going once, twice. All right, so Councillor Savage.
Yes, I'm certainly not going along with the idea that, oh, well, let's just pass first and second reading, and then we
Okay,
can
just
always.
speaking to the amendment, Councillor Savage. We're just on the amendment for the speeder reader.
Yes, that's
Okay.
right. And Council Gesselbrock was just saying regarding this amendment that he was entertaining the idea of not proceeding with it, saying it was better to have after first and second reading and
I rescinded that.
present a third reading. So what I'm underlying is that's not a good idea because past history has shown there's a studious avoidance of passing anything, new amendments at third reading, because it may trigger another public hearing or whatever reason there might be. So I've learned any amendments are best at first and second reading. So that's why I'd be supporting it now and not waiting until later. Thank you.
Okay. Is there any further comments, debate on this amendment? Okay. And again, it's, my understanding is it is best to try and move any amendments early on in the process prior to the public hearing. So at least the public can consider our amendments at that time. So, all right, so I'm not hearing or seeing anything. So I'm going to call the question on amendment. All those in favor and opposed? Okay, that is carried unanimously. Now we're back to the main motion as amended. Further debate on that. Okay, first time speakers to this, and then we'll move to second time. Okay, so go ahead, Councillor Savage.
Yes, for the reasons I gave before, I think this should be referred back to staff, apparently is the best way to do it. And we have already done this, referred it back to staff for what was contained in our last talk we gave from council, but it's come back with no consideration of what we said. And it wasn't just smaller homes, senior housing, or starter housing, and so on. I still think that can be done without amendment to the OCP, but it also referred to green space a number of times in the in what council said, but it's coming back with no green space whatsoever. So I would like to see an attempt made as to what council said last time to show more consideration for what council said. And as I say, we get one chance at development. Once this is developed, there'll be zero chance ever to get parkland for this. It'll all have homes on it. And parkland simply means trails. If it's not an acceptable standard square park, you go for trails. So the highlight in our parks and trails plan are trails. And we'll have zero trails at the rate we're going. Every rezoning we've had has had no trails in it to this point, except the special plan areas, but they're very limited in scope. What the plan calls for is trails throughout Lantzville, so people in this area can walk through to the village on a trail. And there's can be a beautiful trail system along Bloods Creek. We've acquired the Colette property, which we're proposing to turn into a park tonight, and that borders Bloods Creek, and it has a trail going through the property to Colette, but that wasn't a rezoning. Now we've got all these other properties. We should be doing exactly the same thing. If you look at that Colette property, it doesn't take up much room. It's a narrow trail that goes through the property. That's all that's required. It allows people to walk through nature in safety, well off the road. And what a lovely walk that would be. So we're just throwing away that opportunity for the second time on Dickinson Road, where to have a connection to that area directly to the village. So I would like to make a motion to refer this back to staff with instructions to either obtaining more than 5% parkland or looking into funds for trails and pathways per the community amenity contribution document.
So yeah, so Councillor Savage, you're gonna have to restate that probably a
Okay.
little bit slower if you can, please.
So refer this back to staff with instructions to either obtaining more than 5% parkland, or looking into funds for trails and pathways per the community amenity contribution document.
Director Coates, do you have it all? Okay, fantastic. Didn't know. I'll second that one for discussion. Councillor Savage, do you have any?
Yes, I won't
further?
say any more on it, except that right in our community amenity contributions document.
Sorry.
Yep.
So in terms, you have to you can't continue to debate the item. It's basically the reason for deferral,
Oh, very good.
or sorry, for referral back to staff. So yeah, so it's. Okay, I'll speak as a seconder. In terms of this motion, I know I've seconded it, but I won't be supporting the motion, but I wanted to explain my reason why. And I feel like we've already done that process once. We have referred it back to staff and to the applicant, and now it's come back. And I did have a quick question through to staff on that. So through to Director Young, I'm assuming the applicant wished to have this brought back in basically the original form. Is that correct?
That's correct.
Okay, so I feel like we have sent it back. The applicant has sent it back to us for to consider, to run it through its course, and that's basically it. So and with respect to the 5% cash in lieu of and so on, I don't believe we're in a position where we can ask for anything more. So I don't think that would be a worthwhile endeavor. So for those reasons, I can't support the referral. So any additional speakers to the referral motion? Okay, Councillor Savage.
Yes, if I could please kindly respond to that. Like you said, we don't have a right to ask for more. The OCP gives us that right. In fact, I believe it obligates it. It says right in there, the district may apply a
So
bonus.
Councillor Savage, point of order is being called. So go ahead, Councillor Cuthbert. Can you state your point of order?
This is a referral motion.
Yes, okay, so thank you. Yeah, so Councillor Savage, yeah, we shouldn't getting into a debate on the merits of or the contents, sorry, the referral, so. All right, I'm going to call the question on the referral motion. All those in favor to the refer back to staff? And opposed, Mayor Swain's opposed, Councillor Cuthbert, Councillor Wilson, Councillor Proctor, the referral motion fails. So we're back to the main motion as amended. Any further discussion on that? So Councillor Cuthbert, do you have something to add?
Yeah, I think there's been quite a bit of debate on this already by Councillor Savage. I would move that we would call the question at this point.
Okay, so I believe sufficient debates occurred on this. I'm not going to ask for a vote to call the question. We'll just move to call in the question. So all those in favor and opposed, noting that Councillor Savage is opposed, it carries. All right, so we're on to bylaw number 288.
Point of information.
Yes.
So we went straight to calling the question. We didn't do the preliminary, whether we wanted to call the question?
Yeah, as chair, I believe there was sufficient debate
Okay,
on that one.
thank you. I just
move
wasn't
to-
sure.
Yeah. Okay, so moving on to 9B, so bylaw number 288. I'll just make the motion that the District of Lantzville 2021 to 2025 financial plan bylaw number 261, 2020 amendment bylaw number 288, 2021 be given for a second and third readings. Do we have a seconder to that? Second by Councillor Gusselbrecht. Discussion. So through to council, Councillor Gusselbrecht is a seconder if you wish, and then I'll start a speakers list.
I'll withhold my comments for the time being.
Okay, and then through the rest of the council, against our speakers list. Okay, Councillor Savage.
Yes, thank you. Now, this budget is like our similar past two. It can best be summarized by saying it has too many new expenses. At 24,100 for each percent of Lantzville taxes, the 516,200 tax levy, and it might be a little more than that, I haven't got the word on that yet, works out to be 21.42% increase. And that equates to a 71.8.
Point of information,
Yes, what's your point of information, Councillor Proctor?
I'm wondering if, which budget Council Savage is talking about, because this motion refers to the 2020 budget. And I don't remember a 21% tax increase in that budget.
So this is the amendment bylaw. Councillor Savage.
Okay, thank you.
Okay, so and again, this is speaking to amendments to the 2020 budget, not speaking to what we're going to be looking at next week, which is basically and I'll just read it out for people's benefits. So this is when we have our special council meeting to consider the 2022 to 2026 5-year financial plan. So Councillor Gusselbrecht.
Yes, thank you. These are all amendments that we as council have already made. What they're doing is simply amending the previous budget to basically show what we had already voted on. So on that basis, I can vote in favor of this.
Okay, additional speakers on this item. So Councillor Proctor.
The way I read this motion, it's basically housekeeping. It's to change the financial plan so it reflects all the changes that we made to the budget through the year and have already voted on. I think it would be really ludicrous not to support it since we've already made the changes to the budget. So I will be supporting this motion that's about this year's budget, 2020.
Well, it'd be 2021. Well, it's referring to the bylaw 261 2020. So that's, I think, where that's coming from, but it's really the 2021 budget. Any further comments, debate on this item? Okay, so Councillor Savage.
Yes, I've read this already, and I disagree with parts of it. That's why I'm speaking to it and relating it to the past 3 years of budgets where there's been too many expenses. So I'm just saying why I won't support it. And one is the revitalization, village revitalization project is certainly one. The phase 2, I disagree with that completely. I think extending water is a far bigger priority, and it's just not needed. We've already done phase one. It's an unnecessary expense, so I won't be supporting us. Thank you.
Okay, any additional speakers on this item? Okay, seeing and hearing none, I will move to calling the question then. So all those in favor and opposed, Councillor Savage is opposed, that carries. And moves us on to item 9C, which is bylaw number 290. I guess I'll just make the motion, it's probably easiest, so that the District of Lantzville zoning bylaw number 180, 2020, amendment miscellaneous bylaw number 290, 2021 be given first and second reading, and further that District of Lantzville zoning bylaw number 180, 2020, amendment miscellaneous bylaw number 290, 2020 is consistent with the District of Lantzville official community plan bylaw number 150, 2019, and further that the district waive the holding of a public hearing for District of Lantzville zoning bylaw number 180, 2020 amendment, miscellaneous bylaw number 290, 2021. Do you have a seconder to that? Okay, second by Councillor Gusselbrecht. Discussion on the bylaw. So we'll move that to I will take a pass at this point, but through to Councillor Gusselbrecht as a seconder, and then I will start a speakers list.
Once again, I'll hold my comments to listen to others.
Okay, and okay, Councillor Savage, if you wish.
Yes, can I request, please, we go through these one at a time. Some of these are major zoning bylaw changes. One is going for 8 acres from RS1 to a mobile home park. That alone is a major zoning change. So some of them require, most of them require not much comment at all, but some do. So I would prefer if we could, I can speak to the ones I have concerns with, but I can't possibly do that covering such a broad amount of topics just in one motion. So I would, or rather than each, so I would prefer if we go through each one. They're listed in order.
Well, through to you, Councillor Savage, I think what would probably be in order is if there are any specific questions regarding the report. I would agree there are a number of suggested amendments, but if there are any clarification questions through to staff to do that, and to obviously limit any debate or sharing a personal opinion on that until such time we can debate the actual bylaw. So unless there's any objections through to council. So Councillor Gusselbrecht.
I agree that all of us should be able to ask staff questions about these, but we've got a total of 10 minutes speaking time, depending on whether it's rebuttal or not. I don't see any reason to depart from our procedural bylaw.
Okay, so we have an objection to go through it from the point by point. So that being noted, Councillor Savage, we will debate the bylaw as it stands in front of you, or sits in front of you. So I'll start your speaking.
Okay, I will.
I
will start with the Blackjack Mobile Home Park. And first of all, canceling or waiving a public hearing and changing a zoning bylaw is the height of saying residents are irrelevant. This is a huge change. It deserves a complete rezoning just on its own. Residents living adjacent to 7134 Blackjack don't even know this property is proposed to be rezoned from R1 to mobile home park. And there is no rezoning sign in front of the property nor letters sent to adjacent residents. And the key is the OCP does not support the 7134 Blackjack property as a mobile home park because it is not an existing mobile home park. There is nothing about it which resembles it being an authorized mobile home park. And here's the evidence. The previous zoning before our current zoning showed Maple Glen and Parklands mobile home parks as RS7D, which is a mobile home park zone. However, it shows 7134 Blackjack as RS1L, which is not a mobile home park zone. It allows half-acre or 1 acre minimum lot sizes. Our current zoning bylaw shows 7134 as residential 1, but it shows Parklands and Maple Glen as MHP. On July 24th, 2014, a building bylaw report for 7134 Blackjack stated the property is zoned RS1, which permits 1 single family dwelling. There is only 1 mobile home in 1989, which got a building permit. No other dwelling on the property ever got a building permit. In 2014, there were 3 mobiles, 3 park model trailers, and 1 RV being used as dwellings. Park model trailers and RVs do not meet the required standards for full-time occupancy. As a result of this report, on October 27, 2014, Council passed a directive to register on title a notice of bylaw contravention on the title of the property. So, and the whole key, and I talked to BC tax assessment employee, and he said only 35% of the property is tax assessed as a mobile home park, and there are only 4 units on the property which are individually tax assessed. Vancouver Island Health Authority stated there is a private water system from a well and a septic system for sewage, but you have to apply for records to get the details for these 2 systems. So I would move this item be removed from the zoning amendments.
Are you making a motion?
Yes.
Okay, so you'll need to state your amendment motion.
I move that 7134 Blackjack Drive be removed from the proposed zoning amendments.
And through to Director Coates, is that enough information or do you need more? It'd be, yeah, in the table 2A. Okay, I'll second that. Okay, through to the mover, if you wish.
Yes, here's the problem. When this is zoned mobile home park, the zoning goes with the land. It's irrelevant what the owner may be planning in the near future, or what temporary things he may be doing. It's permanently zoned a mobile home park. And if you cross-reference this with the OCP, our current OCP supports 20 units per hectare density on mobile home parks. And that would allow this property up to 65 unit mobile home park. And it would require very likely water and sewer before this is done, but it's got the zoning. So we're already proposing later in our agenda tonight, talking about Clark Drive, Blackjack getting water. So it's just a question of sewer thereafter. And so I think residents deserve a proper rezoning process for this. And that's the way to do it. You put up a sign, send letters to residents, tell them all the implications of it being rezoned this, and have a public hearing on it. That's the correct way to do it. But there's no evidence whatsoever that, there's far more evidence that supports it's not a mobile home park. An authorized one. It's the same as Stan Potty when he put up his RVs. They was taken to court to remove them. So you can't set the precedent of people just putting up what they want on a property completely contrary to zoning, and just because it's been there a while, it's authorized. It's not. So therefore, I'm not even saying if I support it or not, it's a mobile home park. I'm saying it has to be the proper process. Do it properly. Every major rezoning has a sign, letters, proper input from residents. They don't even know this is happening, and a public hearing. That's the way it works. So that's why it must be removed from this. Thank you.
As a second, I just have a question through to Director Young with respect to what's in the proposed zoning amendment bylaw. The maximum number of units on that property, including the house, is limited to 9. Is that correct?
That's correct.
And then if they wish to increase the number of mobile homes at a future date, then they would have to move to a public hearing, or just go through the whole rezoning process, public hearing.
That's correct.
I understand Councillor Savage's concern on this. I do think, either this whole proposed bylaw, it goes to public hearing, or we have to remove some of the sections so they, do to go through the public hearing process. I don't know if this one, I think people should be able to speak to this. With respect to the actual park, I did drive down there. This is quite a while back, because I did bring this up with Director Young a bunch of months ago, and because I had concerns about there's a mobile home park operating and doesn't have the correct zoning, or at least that was my opinion at the time. And anyways, I was told that it was going to come to council at a later date, or there's the district is working with the property owner or something to that effect. So we're kind of in that ballpark realm of dealing with this, but I do think that residents in that area are probably entitled to have the public hearing process work its way through and speak to this at some point before it moves forward. Because when I went down there, I don't know if I can just going off memory here, but it seemed like there was more than what's listed here, and perhaps I'm wrong, but I didn't venture in too far because there was a bunch of signs, I think, saying keep out or private property, so I didn't venture in. So anyways, through the rest of the council. So Councillor Gusbrecht, go ahead.
Yes, through the chair to Director Young. Do you agree with Councillor Savage's characterization of this property that it is not a mobile home park?
Through the mayor to Councillor Gesselbrock, no, we do not agree. It is an existing mobile home park. It has existed for many decades. The zoning is not really relevant. I mean, another good example is the Shore Grove Mobile Home Park on Dickinson Road. Under the previous zoning bylaw, that mobile home park was not zoned as a mobile home park. Under the new bylaw, it is. Clearly, looking at the photos, looking at the buildings on site, they have existed there for a long period of time. The assessment identifies this manufactured home park. It has been independently verified by BC Assessment as a mobile home park. They're well aware of the site. They've spoken with the owner. So no, we do not share the opinion that this is not a mobile home park.
And supplemental, and this was brought up by the mayor, that if the owner wishes to expand, that then he has to submit a normal rezoning application, which of course would go through readings and would have public consultation. Is that correct?
Through the mayor to Councillor Gesselbrock, that is correct. And I mean, if I may relate it to that point, what's in the zoning amendment bylaw is regularizing the 9 units that are on site, and I can confirm that there are 9. There is a house, there are 4 manufactured homes, and there are 4 RVs. And just to reiterate, BC Assessment is aware of all 9 units and is assessing 8 rental pads, 4 for the manufactured homes, 4 for the RV, the house, and the parent property. The whole property is being assessed as residential. So really, I mean, the key reason here why staff are not recommending a public hearing for this particular amendment is it's essentially regularizing what's already on site. So really, what would council be seeking input on?
So supplementary through to staff, did staff receive a complaint from a neighbor of this mobile home park that somebody had told them that it was going to be a 65-unit mobile home park?
Yeah, through the mayor to Councilor Gesselbrock, that's correct. Unfortunately, we received a few emails from residents in the area that someone had informed them that the owner was proposing to expand the mobile home park for a 65-unit mobile home park. Unfortunately, that was a lie. It was incorrect. And staff have responded to those individuals accordingly.
And was that person who told them that Councillor Savage?
I'm gonna call point of order on that.
Why?
Well, I think it's, you know, should be sticking to the issues here and not turn it into,
Well, here's,
and going after individual members of council.
Well-
So and where's the proof?
well,
And
that's.
if we're gonna go there, then we're gonna be shifting in
Well,
camera.
well, here's my issue, is that we have a clear distinction between what counselors do in terms of governance and what staff does in terms of operation. And if a council member happens to see that there's an apparent bylaw infraction, for example, they're not the bylaw officer. And the normal procedure is to go to staff and have staff, the bylaw officer, do that. That wasn't done in this case, and I really object to Councillor Savage taking upon himself walking through.
Point of order,
Mobile
I
Home
haven't
Park.
Hold on,
even-
point of order is being called. Councillor Gusbart, state your point of order, Councillor Savage.
Yes, it's absolutely unacceptable to sit here and have what I said totally mischaracterized. If you want to know what I said, just ask me. I'm not going to put up with being accused of sheer nonsense. You've done this in the past and I won't
Okay,
accept it,
Councillor
period.
Savage.
We have a letter from a
Okay,
resident saying that somebody told him there's going to be 65
Okay, order,
units
I
there.
need order. Enough. Otherwise, we're shifting in camera. If we're gonna go after individual members of council for conduct, then we're going in camera. As simple as that. Strongly urge that council stays focused on the motion at hand. If there's a question of what a councillor did or did not do, then we'll take that up in an in-camera session. Okay. All right, so is there a further comment, debate on the amendment motion? Okay, Councillor Savage.
Yes, the problem is perfectly clear. This puts a huge advantage to this property becoming an authorized mobile home park. And as the OCP states, it supports up to 65 units on this property, 8 units per acre, 20 per hectare. So by authorizing this now, you will not need an OCP amendment, and the zoning and the OCP supports this amount. So someone, if this property is sold, it was attempted to be sold a couple of years ago to a mobile home park investor, he can point to the fact he's compliant with the OCP because it's an existing mobile home park and we're making it existing tonight. If we pass this, we should not be saying that it's an existing mobile home park. As I say, in 2014, they didn't accept it was the council. That's why a bylaw contravention was placed against the property. And the RDN building bylaw office said the same thing. It's zoned RS1. This is all unauthorized. They weren't even building permits for all but one
Point of order
of these things.
Okay, and your
So-
point of order, Councillor Bright.
is that Councillor Savage is referring to conversations with the RDN and other evidence. Where is this evidence? Nobody called me from the RDN. That information isn't before all
Okay, so
councillors.
Councillor.
No,
Councillor Bragg,
wait a
you're
second. It's
hold
only fair
on,
that
Councillor
information
Bragg.
be before all of us.
Calling into order. Do not interrupt me as a presiding member of this council. It is unacceptable. It's
I
out of
was
order.
talking.
Pardon me?
I was talking.
Yes? And I asked you basically to stop,
And what's the reason to stop?
to address your point of order. You're debating, not stating a point of order. Point of order is referring to parts of our procedure bylaw that are being violated. So if Councillor Savage is not on point and he's not speaking to the amendment bylaw on the table, that's fine. That's fair game. If you're asking for a point of
That's my
clarification or what
point.
have you.
That's my point. Let's get back on to what the motion is before us.
Okay, fair. So
So I sent to all of council by email yesterday, I believe it was, the reference to 2014 two council meetings where this report was part of the one in the summer of 2014, and the bylaw contravention was approved to register on title in the October 27, 2014 meeting. So there's two steps here. Number one, we're doing a major rezoning, going from RS1 to zoning it as a mobile home park. It's a major zoning that residents aren't aware of. Step two, once it's been authorized as a mobile home park, then it relates to the OCP, which supports up to 20 units per hectare. And I said clearly those two things, just the way I said it now, to residents. And what I said is completely factual. And
Point of information.
and as a
Okay,
point of
Councillor-
order, point of information is not a reason to interrupt the councillor. There's nothing that
So
justifies it.
Councillor Proctor, I'm going to wait until Councillor Savage is finished and then you can state your point of clarification. or
Thank you.
information.
So to refer to saying that someone was lying is a ridiculous statement. And
Okay,
now
so Councillor Savage, let's move
I'm
on
just
from that.
defending myself. What
Oh, I
I just
understand.
said
Point of
was
order.
factual. Thank you.
Okay, point of order has been called. Go ahead, Councillor Proctor.
I don't think it's appropriate to call anyone names on council or on staff. I think it's in
Thank you.
contravention of our code of conduct.
Yeah, I think Councillor Savage was referred to him getting called a liar. So
Yes, no problem.
anyways, Councillor Savage.
So that is my point. It's very important we have a proper process. However you characterize this, it's going from RS1 to a mobile home park. And in any books in any municipality, that is a major rezoning change or a major zoning change for an 8-acre property. If this is going from RS1 to a mobile home park, then it has to be proper process, a sign put up and residents giving proper input. They haven't even been notified. It's not my job to notify them. So if it's going to be done, then do it properly. And then we can speak to whether it's a good idea or not. And there's other uses that I think might be better in there, such as tiny homes where the owners can own a piece of the land. It's a
Okay,
better
Councillor
investment.
Savage, I'm
Thank
going
you.
to interrupt you there. Thank you. So Councillor Proctor did call a point of information or clarification. I can't remember which one, but go ahead, Councillor Proctor. And you're muted.
Sorry. I'm looking at the email that Councillor Savage sent us yesterday. And I would characterize it as a conglomerate of facts that aren't strung together in any way. So I just wanted to clarify that. And my question is, I'm wondering how Councillor Savage obtained the attached pictures, because they seem to be taken from private property where there's no trespassing signs posted.
You care to respond, Councillor Savage?
Yes, I'd be most happy to. The Landlord Tenant Act, which is provincial legislation, allows any visitor of a resident to visit that tenant. There's nothing that justifies a landlord banning people from visiting any tenant, and these tenants at these property are my constituents. I have every right to visit them anytime I so choose. And the fact you're claiming that it's private property underlines that it's not an existing mobile home park. You can't forbid
Okay, so Councillor
the
Savage, we're not
public
gonna
to go
debate.
into any mobile home park. It's public. It's allowed to visit any resident of that they choose. Thank you.
Okay.
I would like to be put on the speakers list, but Director Young's hand is up. I'd like to
Yeah.
hear what he has to say. Thank you.
Thank you. Director Young, if you wish.
Yeah, Mr. Mayor, I just wanted to clarify, I keep hearing RS1, but there's no such thing as RS1 zoning. The property is zoned R1. And I think it's just important that we refer to the correct designation for the public watching the council meeting.
Right. Fair enough. Thank you. Now we're off to Councillor Proctor. Go ahead.
I think that my question was answered. I'll raise my hand again if I need to. Thank you.
All right, so interesting debate nonetheless. But with respect to, I'm trying to listen carefully to all points here and to consider them. And I struggle with the fact that, you know, we are going to be rezoning this as a mobile home park. And if the OCP states that, you know, unless it's Councillor Savage is incorrect, that there can be 20 units per hectare or acre, hectare, I believe it was. Then I think his assumptions would be correct. So, you know, if an applicant was to come back to us at a later date, council, like, I don't even think would actually even come to council. I'm just trying to process this, Director Young. Like, if we have it in our zoning bylaw, unless we're doing a site-specific zoning, is that what this is?
Yeah,
Just
Mr.
thinking
Mayor,
out loud.
if I may, let me put it this way. If the property is not zoned as a mobile home park, the policy still applies. And the owner could approach the district and council and say, I want to seek a zoning amendment to permit 20 units per hectare on this site. The policy applies and council would consider that. And in the same way, if the property is zoned mobile home park and the permitted 9 units that are in the zoning amendment bylaw are passed, then the policy would still apply. And the owner, if they wanted to increase the number of units, would have to apply for a zoning amendment and seek council approval for that. So whether or not the property is zoned as mobile home park has no bearing on whether it's an existing mobile home park. Logically, it exists if it exists. The zoning is quite frankly totally irrelevant. And so in any scenario, if the owner wants to seek approval to increase from 9 to X number of mobile homes or RVs or homes on the parcel, it would come to council and council would decide. And you have unfettered discretion to either deny or approve that zoning amendment bylaw despite the OCP policies.
Thank you for that. I still struggle, and again, I'm thinking out loud here, in the sense that, you know, if it's approved as a mobile home park, that the land is zoned as that, or has the zoning for that, and then, you know, given the fact that it's an 8-acre parcel, I guess council would be in a really tough spot to say, sorry, we don't support this application, because everything would be lining up. I mean, it's consistent with OCP in terms of having 20 units per hectare. And then you have the zoning is in place to call it a mobile home park, even though it's only for 9 units on 8 acres. That's quite generous or a very low density mobile home park. To me, I think it would be simpler to just deal with it all in one go rather than, do this tonight and then have the applicant come back at a later date and go through the whole rigmarole of rezoning to try and pump up the numbers. But anyways, those are some thoughts. Councillor Wilson, go ahead.
So through the mayor to Director Young, I'm just trying to get clear on this. So at this point, as much as it says that there's, 20 mobile home units per gross hectare in the OCP, the owner would still have to come to council if they wanted to increase it from 9 to say 10 or 60 mobile units. They would still have to get a zoning change, which would then come before council, which would then also have a public hearing to it. There'd be a whole other process to it. Just because it says it in the OCP, the zoning is different from the OCP. Am I correct in my thought process?
Through the mayor to Councillor Wilson, that is correct. And if you look at the OCP policy, it makes no mention of zoning. It makes no mention of whether sites are zoned for a mobile home park or not. It just simply says existing mobile home parks, 20 units per hectare. So again, whether or not council zones this as a mobile home park has absolutely no bearing on that policy.
Thank you.
Okay, so I think we've had a fair bit of debate on this one, unless you have new information, Councillor Savage.
Yes, I have 3 pieces of new information. First, the OCP, it's on page 63, item 6. It's in the residential section 5.2.7, and it reads, existing mobile home parks are recognized as permitted uses at density of 20 mobile home units per gross hectare, 8 units per acre. All mobile homes will be serviced by municipal or on-site water and sewage treatment systems approved by the Vancouver Island Health Authority and or the District of Lantzville based on the most stringent requirements. So there it is in the OCP. And as you've noticed, it says that each unit will be serviced by municipal or on-site water and sewage treatment. Well, I don't believe this is a municipal water system. I was told by Vancouver Island Health Authority that it's from a well, a private well, this system. So that's the first item. The second item is the tax assessment employee I was speaking with. I asked them that specifically if they verified that this was a mobile home park, and he said no. They didn't verify it. They were simply told or assumed it was, but they didn't verify that it was at all. And he said that 35% of the property was taxed under mobile home park in terms of tax assessment. So the key here is this is a major step, and that's the whole key. To authorize it as a mobile home park is a major zoning change, and residents haven't even been informed of it. There's no sign and so on. It needs proper process to change this zoning. And the last thing I'll say is they're being rewarded for breaking bylaws, and that's why there was a covenant put on it back in 2014. He never cured these infractions. So he's being rewarded, but a decision back then is it was not in compliance with the bylaws. And a point was made in the report that it was zoned RS1. That's the old zoning. And it was not zoned mobile home park. That's why it had a covenant registered on title. It's never been cured. And now we're rewarding this by giving rezoning. So I can think of many non-conforming things or illegal things that have been done on properties. And so what I'm hearing is that because they exist, they have to be approved. Well, that wasn't the case, as I say, with Stan Potty. His RV park was ordered to be removed and he was taken to court on it. And there's many, many other
Okay, Councillor Savage, just on new
infractions. So
information. you're
I would
repeating.
urge we do this properly, remove it from this housekeeping process. It's not housekeeping.
Okay, so Director Young, I see your hands back up again.
Yeah, Mr. Mayor, I just wanted to offer, if council would like more information on the servicing, the BC assessment, and the notice on title, I can provide that.
I personally think it would be helpful, you know, yeah, that's just
Okay.
my opinion though.
All right. I mean, would you like me to provide the information?
Or you're gonna give it right now?
If council wishes.
Okay, sure. I didn't know if you're gonna email it or if you're gonna send it out. Yeah, if you have that information now and you'd like to share it, go ahead.
Sure. So if you look at the policy, it says service by municipal or, and so clearly there's no municipal water or sewer at the subject property. In the long term, hopefully that will be the case, that there is municipal water and sewer there. The alternative is on-site water and sewage treatment systems. So there is a private well on the property that services the mobile home park. There's also 2 independent septic systems. Island Health has reviewed both the water and the septic system. The septic system has been approved by Island Health. The water meets municipal standards for both quality and quantity. The second point around BC assessment, I can confirm that the information received by Councillor Savage is incorrect. Staff contacted BC Assessment this afternoon, spoke to management and confirmed that BC Assessment is well aware of the property. They've been on site. They know that it's a mobile home park. From their perspective, it is a mobile home park. And there's some nuances to how the site is assessed. I probably don't need to get into a whole lot of detail on that. The third point, I heard reference to a covenant. There is no covenant registered on title. It's called a notice on title. When there's a bylaw infraction, that's one tool that council can use to advise prospective purchasers that there was a bylaw infraction and to indemnify the municipality from claims as a result of those bylaw infractions. But the ultimate goal or aim of the notice on title is that the owner seeks compliance with municipal bylaws. The first step to do that is to regularize the zoning. Without regularizing the zoning, the notice on title can never be removed, and building permits cannot be issued for those mobile homes. So I mean, really the owner is doing what they're supposed to do by requesting and seeking zoning to regularize that use so they can obtain building permits from the district. This is simply the first step, and they're doing what they're supposed to be doing.
Okay, thank you for that information. I did have one follow-up question just on the BC assessment. Forgive me, I haven't looked it up in quite some time, but I believe when I contacted you many months ago about this, you know, one of my concerns was, you know, this property is, in my opinion, not paying their fair share of taxes. So you have a number of residents living on this property, using Lantzville roads, having access to the Lantzville Fire Department and all the other municipal services. But they're, in my opinion, not paying their fair share. So with the BC assessment, you know, coming in and looking at this property, do you believe that well, I guess it's probably a tough question to answer, but in your opinion, do you believe that the assessed value of this property will be going up?
Yeah, so when we spoke with BC assessment, the way it works and the reference to 35% is the assessment is based on revenue generation from the mobile home park. They've only assigned 35% through the revenue stream because only 35% essentially is being used as a mobile home park. But what they're doing is they're saying 8 pads are being rented out and we're assessing it on that basis. That happens to align with what's occurring on site, which is 4 manufactured homes and 4 RV pads. But to be clear, the whole site is classed as residential and they are paying taxes for the whole site. But in addition to that, they're being assessed based on a revenue stream for the rental of those 8 pads. So yeah, BC Assessment confirmed they're definitely paying their fair share of municipal taxes.
Okay, thank you for that comment. Councillor Gusselbreck, and then I'm probably going to be calling the question here. So, okay, that was the next. Unless there's new information, I am going to call the question. So, and
Sorry,
calling question on the amendment. Sorry, I heard Director Young.
Yeah, Mr. Mayor, just sorry, one further point on the BC assessment. So in addition to the parent parcel being assessed and taxed, the 4 manufactured homes pay taxes through separate folios to the municipality. So not just the parent property and owner and house, but the 4 owners of those manufactured homes pay taxes for the value of those 4 improvements.
Thank you for that. It's good to have, that information, because again, it leaves one day. If you just look up the main property, you kind of led to believe that, they're paying taxes on that assessed value, yet there's all these properties there. So thank you for clarifying that. All right, I'm going to call the question on the amendment. Councillor Savage.
Yes, just one new piece of information, please, and that's fine for me.
Less than 30
And-
seconds.
You got it, but what you said, they're not paying their fair share. You're 100% correct. It's in the neighborhood of a tax assessed value of about $60,000 that goes with the property. That's a tiny amount of taxes that comes out of 60,000 tax assessed value, and only 4 of the properties are being tax assessed. There's campers in there I've seen being occupied. There's boat storage. There's innumerable things they're not paying their fair share, period.
Yes. But just for clarification, just so everybody understands, and so even I understand through to Director Young, when it's tax time, and like how many notices are being sent to that property? Is there 1 to the main owner and then 4 for the individual mobile home owners? So it'd be essentially 5 tax notices going out. Is that correct?
That's correct. So for 2021, the property owner paid taxes on $1.5 million in overall assessment for the property and for the house and for the revenue stream for the 8 pads for the mobile home park, and then 4 tax notices, 1 for each of the manufactured homes.
Okay, thank you. I just wanted to make sure everybody's clear on that. Because again, if you just go off of BC Assessment's website and you just click on the main parcel, you're not going to get those other 4 folios. And then, unless I'm wrong, is that correct, Director Young? Not to beat this to death, but
that's correct.
Okay. So you just got to be careful when you use the BC Assessment, because again, like I felt somewhat victim to that as well, because it's not clear. All right, calling the question on the amendment. All those in favor and opposed? Councillor Wilson, Councillor Gusselbreck, and Councillor Proctor opposed. The amendment fails. All right, Councillor Gusselbreck.
I would move that the question be asked.
All right, so we still have, well, if there's additional speakers on the rest of this motion, I think it's in order that you can debate it further. We're just disposed of the amendment. So Councillor Savage.
Yes, I have another
Oh,
amendment.
sorry, if there's any additional first-time speakers to the main motion. And Councillor Gusselbreck, if you can just turn your microphone off, we're just getting some feedback, and Councillor Savage too, thanks. Okay, so no first-time speakers. Actually, I don't know if I spoke to the first time. Okay, anyways, Councillor Savage, go ahead if you have an
Yes, I'd like to make an amendment. I move to amend this amendment bylaw in number 2G1 by striking the words or personal watercraft.
Sorry, which page are you?
That's page 43, second to the last paragraph.
Page 43.
So under the definition for automotive repair.
Yes.
Okay, I'll second that. Sorry, yeah, okay, yeah, go ahead. I'll second that, yeah. Director Coates, do you have the right reference?
Yeah, I just wanted to again preface
Councillor Guswork, if you don't mind turning.
that the goal is to make an amendment to the motion that's on the floor. So the motion on the floor is what you know. And so it'd be that the motion on the floor be amended by adding after in quotes, second reading quotes, comma. So then in quotes, what you would be adding to the motion as amended in item 2G1 by striking quotes or personal watercraft.
Okay. If you wish to speak to a councillor.
Yes, thank you. Yeah, I went through the survey and there was only 2 mention of boats in the survey and both were negative. One person, not one person has asked for boat repair. So why is this in here? And it's not stated that boat repair is being added. It's just simply changing a definition of automotive repair, which makes it de facto that now boat repairs will be allowed in residential areas. So I have no idea what the reason for this. Boat repairs are nothing like automotive. Big boats being towed through residential properties is not a good thing. You can get 22, 24, 26-foot cabin cruisers being towed, and that's not an appropriate use. This is a light industrial use boat repair, and next to no one has a building big enough to hide the boat while working on it, which is a prerequisite for the automotive definition. So we're assuming the same would apply for boat repairs. And this, so boat repair can mean it's not just restricted to motors. It can mean fiberglassing, painting, sanding, boat hulls. And this is purely light industrial operation. I've been to many boat repair places, marinas as well, and it takes a lot of room. It's a major operation. And we heard during the original zoning bylaw, the majority was highly against automotive during that time. And now to add boat repair on top of that, it's far more onerous than automotive repair. And automotive, you drive there, you get it repaired and you leave. With boats, they're stored there for some time, waiting to be repaired or waiting to be picked up. So then now you've got boat storage happening on residential properties. So none of this makes sense. And as I say, it was not, the whole idea that was the survey was to get feedback on what changes to make. And this change was never asked for by anyone. It just came out of the blue. I don't know the reason for it. And as I say, it's industrial, and there's also the safety issues of now pulling big boats, and they're very tricky. I've driven
Order.
boats.
Councillor Savage has
Point of order.
spoken longer than 5 minutes.
Actually, I don't believe he has. I've been timing, and on the amendment, he's just at 3 minutes as I'm speaking.
So with boats, I've driven boats on trailers for most of my life, and they're very tricky to turning corners, but mostly backing up. And in spite of all my experience and those that have experience with backing up boat trailers, you still make mistakes. It's, you know, it's very common. You don't quite turn the right way, or you turn too much or too little. It's backwards turning. It's counterintuitive. So there again is a problem in a residential area. If you're backing up big boats to get them dropped off for repair and so on, there's residents living here, and that means kids as well. It's just not a safe thing to be doing in residential areas. So that's why it shouldn't be in here. It was never asked to be in here. And it's absolutely more of a light industrial. Everything to do with home-based businesses is more a light thing, like woodworking or artisan artwork, you know, knitting, conducting, accounting, all that sort of thing. It's a light footprint on the neighborhood. This is right out of a light industrial zone is what this is. Thank you.
Okay, additional speakers. So it's the seconder. I'll speak next. I don't know if I entirely support just removing it. I did speak to Director Young about this, and it's more, you know, when you look at the definition, personal watercraft, it doesn't necessarily, like in the, you know, when it's after that, it says, but excludes auto body repair. Well, the auto body repair would also apply, and correct me if I'm wrong, Director Young, to repairs to the hull. So that would be fiberglassing, gel coating, all that fun, stinky, obnoxious, whatever toxic stuff that goes on when similar to auto body repair. Personal watercraft could include things within, so it could be the engine, could be electronics, could be steering, could be trailer repair, those types of things, but would not include the what would be the equivalent to auto body repair. I was going to suggest an amendment to this one and just instead of having auto body repair, just have auto body /hull repair. So it would be a little bit more encompassing of you know, the personal watercraft as previously mentioned in the definition. But I do understand the amendment that's before us right now, and that is to delete personal watercraft from the definition in its entirety. The one thing we have to be cognizant of here is whatever is being done, whatever type of automotive, recreational vehicle repair, boat repair, it is to be done inside a building, an enclosed building, as it's stated. So it says, and the thing must be fully located, or sorry, located fully within a permitted building. So one would assume that this is not out in someone's driveway or wherever. This is within an enclosed building, and it was similar to when we originally dealt with the zoning bylaw with automotive repair. Was if you can't see it and you can't hear it and you can't smell it, what's the big deal? You know, it's out of sight, out of mind, and that's the way it should be with any home-based business. And as we have in our zoning bylaw, or not zoning bylaw, but just our good neighbor bylaw, anything that ruins the peaceful enjoyment of others, especially when it comes to noise, can be dealt with respect to the zoning bylaw or the good neighbor bylaw. So if this doesn't, again, I don't know if this is the right amendment to be made, and for that reason, I won't be supporting it, but I will be bringing forth a similar amendment, but just to deal with the auto body repair as applicable to boats. So that's my speech on that. Through to you, Councillor Gusselbrecht, go ahead.
Yes, I like the mayor's thought. So could we move ahead? And I would move that we call the question on this.
So I will call for any other first-time speakers, and then I am inclined to call the motion on this, or call the question. Okay. Hearing none, I'm going to call the question on amendments. All those in favor of the amendment and opposed, Mayor Swings, opposed, Councillor Gusselbrecht, Councillor Wilson, and Councillor Proctor. Amendment fails. I will attempt an amendment. and is to amend the zoning bylaw amendment, bylaw number 290/2021 under section, oh, what number is that now? Shoot. Yeah, well, it'd be under G1 automotive repair definition. And as it states there, but excludes auto body. And so after auto body, put /haul. And that's it. And it would still have the word repair. So after the word auto body, /haul. And that's the amendment. Okay, so I have that. Do you? 2G1, that's correct. And then it should read excludes auto body /haul repair. Okay, so, and seconded by Councillor Gusselbach. Okay. Discussion on the amendment motion, not much really to add. I think it just brings it into alignment with the personal watercraft that which precedes it. So through to the seconder.
I'm in agreement.
Okay. Any additional speakers? So Councillor Savage, go ahead.
Yes, I'm afraid I won't be supporting this because it doesn't address the safety issues in bringing light industrial or industrial uses into residential areas. The personal watercraft as defined in the zoning bylaw means a watercraft that can be towed on a trailer and that is used for small-scale personal recreational use. So as I say, that definition can mean any motorized craft people use for fishing and water skiing, having fun, and so on. And as I say too, it doesn't address the fact that boats will be stored, waiting to be repaired and waiting to be picked up. So in essence, what we're doing, we're approving boat storage as well as work on boats. And once it's passed, it'll expand and can mean all sorts of things to different people. So I won't be supporting it. Thank you.
Okay, this is a follow-up with respect to I see it as being no different to the storage of vehicles. There simply shouldn't be storage of vehicles waiting to be repaired. The vehicles, and correct me if I'm wrong, Director Young, since it's your department, but if someone is having a vehicle repaired, it gets towed to the property, into the shop, it gets its repair, and then it leaves the shop off the property. It should be that straightforward. So I see the same thing applying to a boat. If a boat's getting repaired on a property, it gets towed to the property. It may sit in a yard for a little bit until it can go into the shop. The work is completed in the shop, and then it's off the property, next customer. I think it's pretty straightforward. And again, if you can't see it, smell it, or hear it, there shouldn't be an issue. So Director Young, I don't know if I'm oversimplifying it or if that's.
Nope, that's a correct description. That's definitely correct.
Okay. All right. So, and if a neighbor takes exception to that, then there's the mechanisms in place that they can follow through on and file their complaint and so forth. All right. So unless there's anything new or additional information, I'm inclined to call the question. Okay. Hearing or seeing. Sorry. Yeah. Just voting on the amendment, which is after auto body /haul. Not the word /, so just one of those. Okay. So I'm going to call the question then on the amendment. So all those in favor, opposed, noting that Councillor Savage is opposed, the amendment carries. Now we're back to the main motion as with that amendment. Any additional amendments? Okay, Councillor Savage, go ahead.
Thank you. This is sorry, Director Coates, if I could just phrase it that using Director Coates' prelude to the motion, I move to amend section 2C by not making any changes to the setbacks for intensive agriculture.
So that would be on page 43 under C3.
Yes. That chart. No, I'm just going back to, I'm suggesting to go back to the way the current zoning bylaw is and not making any amendments with respect to intensive agriculture setbacks.
Could ask Director Young to speak to it, but I'm assuming that if it's not, oh, so there's other numbers that are in the existing table. So
The setback's currently 30 meters. The proposal is to allow smaller buildings to be only a 15-meter setback as opposed to the everything being a 30-meter setback.
So Director Young, what would be the wording in those rows if those rows weren't amended?
The wording is simply to not amend the
But
zoning bylaw with respect to intensive agricultural setbacks.
Okay, so Director Young, if you can answer Director Coates's question with respect to what numbers are currently, I don't have zoning bylaw number 180 up in front of me, so I have no idea what the numbers are offhand, but through to you, Director Young, if you can.
Yeah, thank you, Mr. Mayor. So I believe the amendment motion is to delete section 2C3 because 3 deals with replacing the existing table with this new table. So if that provision of this bylaw is deleted, it would just remain as written in the current bylaw, which is a 30-meter setback for cannabis production and intensive agriculture, regardless of the size of the intensive agriculture building, and then 8 meters for any other structure. So this new table just differentiates between small intensive agriculture structures and large intensive agriculture structures.
thank you.
Okay. Hold on. So that's being, I guess, moved. Do we have a seconder to that? Okay, so I'll second that for discussion. Through to Councillor Wilson, yeah.
Just through to Director Young, I'd just like to ask what is consistent with what the ALC, what their, I guess, recommendations are for intensive agriculture, large buildings, small buildings. What is the current act for the ALC state?
For the Mayor to Councillor Wilson, it's not the ALC or the ALC Act, it's the Ministry of Agriculture. So regardless of whether the property's in the agricultural land reserve, the Ministry of Agriculture has established a guide to bylaw development in farming areas. And I spoke with the Ministry of Agriculture staff about this, and they agreed that smaller agricultural structures that would house animals, so intensive agriculture, could go as close as 15 meters. That's what the ministry's guide to bylaw development in farming areas says. However, for larger intensive agriculture structures, more than 540 square feet in area, staff feel that remaining at that 30 meters is the right thing to do. But for smaller structures that house livestock or horses, there's no need for that structure to be 30 meters away. And so this change is to align with that ministry's guide to bylaw development.
So through to Councillor Savage as a mover, if there's.
Yes, thank you. I've seen so many examples of this where you get things built up around residential areas, built up around farmland. And the first thing that can happen is they start complaining about operations on the farmland in terms of smell and dust or whatever. And so the best thing to do is to just not set up that conflict. And that's why I think it was right in the first place to keep adequate separation between residential housing and farmland. And just because it's small doesn't mean it can't be something that's bothering people, be it storing compost, be it a horse, be it roosters that crow in the morning, wake people up, and so on. Just keep the buffer. It's still intensive agriculture is what it's classified as. So I would recommend keeping that buffer to keep the peace for people farming, just so they can be left alone and not bothered with complaints from neighbors. I've seen it just too often. And so this is to simply to keep the peace. It had it right the first time. And again, I've no idea the reason for the change. I didn't see anything in the survey that spoke to this. So thank you.
As a seconder, I guess really the question is through to staff is what led to this change? Like, was it just part of the review? Like, was it a request? I'm trying to understand why the requested change has come forth. So through to staff.
Yeah, Mr. Mayor, and perhaps I can clear something up. This zoning amendment bylaw is not only to do with the survey that went out to residents and home businesses. This is a miscellaneous housekeeping amendment bylaw. And as we said in the staff report, at least every 1 to 2 years, council and the district should look at the zoning bylaw and make amendments along the way to be consistent with best practice. You know, essentially, as you hear from residents, you learn. Staff have been contacted by a number of residents who you know, feel that 30-meter setback is a little bit onerous. And it's interesting. It's from the Ministry of Agriculture's perspective and the Agricultural Land Commission, it's actually not the priority to ensure that residential land uses are protected from the impacts of farming. It's actually the reverse. It's imposing setbacks that are too significant that has an adverse impact on farming, which feeds our society and our communities. So it's actually quite the opposite. Things like buffers and separation actually needs to take place on the residential side, not on the agriculture side. And the best practice is to ensure that use of that prime agricultural land is maximized. And one way to do that is to reduce setbacks where appropriate.
Thank you for that. Any further debate, comment with respect to this amendment? Okay, hearing none, I'm going to call the question. All those in favor and opposed? Councillor Wilson, Councillor Gus, Mayor Swain, and Councillor Proctor opposed. The amendment fails. Any further amendments? Okay. Councillor Savage.
No further amendments, but I'll just finish off with a brief comment why I won't be supporting this whole bylaw change. And that's simply, it's about process. And I must underline that proper respect of residents. Number one, you don't waive a public hearing when there's major things contained in it's not a housekeeping at all. There's major changes in here. And it's like the last zoning bylaw, rezoning Aspen Grove School was the same story, going from only a school and a residential use to all these other commercial uses. That's
okay. Point of order is
major.
being called. Councillor Savage, can you state your point of order?
Not on point. What does this have to do with Aspen School? Aspen Grove School?
If you can bring your point around quickly on that, Councillor Savage.
Well, it has everything to do with it, because once again, we are doing a major rezoning without a sign being put up, without letters being sent to residents explaining what's going on. And it's just treated as a housekeeping issue. That's wrong. That's not respecting residents like they should be. They deserve to know what's going on. And this is not housekeeping. It's a major change, completely rezoning an 8-acre property. And number two, I do not believe in waiving public hearings. And the third thing is there's no justification for waiving this public hearing because it's not an existing mobile home park. So I won't be supporting it. Thank you.
Okay, additional speakers. So Councillor Proctor, I see your hand is up.
Thank you. I would just like to say in closing that I've listened carefully to all of the comments made. And I consider all of the information provided to us by staff to be factual. And I am not opposed to public hearings, but I feel that most of these items are housekeeping items, number one, or have already been consulted on because we did an extensive survey about the home-based businesses, and the changes that we're making to the bylaw are based on the feedback that we got, which I thought was very interesting. I read through all of it, and so I will be supporting this. The difference between this trailer park and any other trailer parks that have been mentioned tonight that were not considered to be legal is that this trailer park existed before there were bylaws, zoning bylaws in this community. And so there's a history. It has existed a long time. And if they want to change it to 65 units, and unfortunately, a lot of people got some misinformation. Somebody went door to door and.
As a point of order, I think we've gone through this. It's unacceptable. I stated exactly what I said, 100% correct. So enough, please. Thank you.
It's not enough, please. I'm allowed to speak, and I never mentioned your name, Councillor Savage, so I don't know why you took offense.
Yeah, as a point
Yeah,
of order, please.
Point
Thank
of
you.
order, could you please not interrupt me when I'm talking?
Okay.
So I would like to
Councillor Proctor,
finish my point, yes?
Go ahead. Yep.
Thank you. So,
Sorry,
Hold on,
sorry
Councillor
to
Savage.
interrupt. I called a point of order, so I'd like a ruling on it, please. Thank
Okay,
you.
what was your point of order?
My
Councillor
point of order is it's unacceptable. Number one, running down a fellow councillor.
Okay,
And number
Councillor
two, falsely characterizing what I said. I said what I said, and it's 100% factual. Thank you.
I've never mentioned your name or said anything that you said, Councillor Savage, so you misheard me. I said, unfortunately, there's some misinformation out. Someone apparently went door to door and told people that are living on Blackjack that we're going to be voting
As a
on
point
making
of
this
order,
a
again,
65
please.
unit
As a point of
trailer
order,
park.
please. That
Okay,
means
point
you
of order is
stop
being
talking.
called, Councillor Proctor, so I have
Okay,
to
let's hear this
let
one.
Councillor Savage state his point of order.
Let her
and then
roll.
If I can have a chance. Go ahead, Councillor Savage.
All right, I believe in proper process. I've called a point of order. It's being, the ruling has been made and it's being ignored. I was the person that went to 2 doors and people were home on Blackjack. So she's referring to me, Councillor Proctor is.
I'm
and
not
I've
referring to
Okay,
you,
if you
Councillor
can
Savage.
please not interrupt, Councillor
And
Proctor.
I've stated what I've said, and now for the third or second time, she's proceeding with the
I
same
have a
line
name.
If you can please not interrupt,
About-
Councillor Proctor.
denigrating what I did, which is
Okay.
untrue. So you've made
So-
the ruling, it's inappropriate. So I must call a point of order every time she does it. Thank
Okay,
you.
Councillor Savage, your point of order is noted. I believe continuing to refer to someone providing misinformation, which we've already clarified earlier in the meeting, has no bearing on closing arguments at this point. So if we can move past that, that'd be much appreciated. So through to you, Councillor Proctor.
I'm sorry that there was misinformation, and I'm sorry that what I've said has been misinterpreted. And I would appreciate if my fellow councillors referred to me by my name. I think we have a code of conduct that dictates that we treat each other respectfully. So in all due respect, I expect to be treated the way I speak to others. And I have not accused Councillor Savage of anything. In closing, I believe that the information provided to us by Director Young is factual, and I will be supporting this.
Okay, additional speakers on the motion as amended. For myself, I'm of two minds of this. I'm somewhat satisfied with the information that's being provided to us. I do have some remaining questions, which I might work through a little bit on in the next minute or two. But the part I'm really struggling with here is waiving, holding a public hearing. I understand the rationale has been provided. However, I think in terms of just fair process to residents, giving them an opportunity to have input on this, or at least listening to them and considering what may come forward to us is in order. That's just my opinion. Our agendas are prepared for us typically Wednesday, Thursday, the previous week before our meeting. So we have about a week prior to our council meetings, and for residents, unless they're paying attention, they may not know how this stuff is going to be impacting them, or they may want to have input into this. And I think there needs to be that process needs to happen when we're dealing with a zoning bylaw. Just my opinion. But with respect to the, one of my concerns in here is just around automotive repair, and on page 43 of our agenda, it says the parcel size has to be at least 0.8 of a hectare. So really, unless your property is 2 acres in size or larger, that ship has sailed for you in Lantzville. There's other areas that, the ones I'm familiar with anyways would be Nanaimo. There's certain parts in Nanaimo where you can do half an acre. And then also out in Cedar, you can do half an acre and have automotive. And again, I am of the mind that if you can't hear it, smell it, or see it, or taste it even, then, what's the problem? And I see uses like fine woodworking and metal work and so forth. Those can be just as loud as someone who's doing wrenching work. And I'm not going to get into that because I've debated it last time we dealt with this when the original zoning bylaw. But I think the 0.8 of a hectare is just far too large. And again, I wonder how many properties this now excludes from having automotive as a permitted use on their property. So and I don't know if Director Young knows offhand, and I'm not trying to put you on the spot, Director Young, but like how many properties in Lantzville are actually 2 acres or larger in size? Like what percentage of properties are we talking about? I think it's probably a small number, and the rest of the properties it wouldn't apply to. But anyways, Director Young, I don't know if you know offhand approximately percentage wise, and if you don't, that's fine as well.
I don't, Mr. Mayor. I was trying to find that map in the OCP, that colored map that shows the number of parcels of different sizes. Unfortunately, I can't find it as quickly as I hope.
I should know, because I think I originally did that and tallied up a lot of the property sizes, but I can't think offhand approximately how many it would apply. But I believe the percentage is fairly small. So it really only permits a limited number of parcels in Lantzville to actually do automotive repair, or in this case, it could be RV repair or watercraft repair. So, I have a problem with that, and I'd like to hear from the public on that as well. But anyways, I'm not going to belabor this. We'll go to, I think, Councillor Proctor, you have your hand up again, and then Councillor Savage, and then unless we have additional speakers, I will call the question.
I'm wondering through you to staff, if we don't pass this tonight, is the district going to have difficulty proceeding with the business licensing at the 1st of January that we've required?
Matter, Councillor Proctor, I don't know that I would characterize it as difficulty. What we said in the staff report is we anticipate that there's going to be a grace period, in particular for these zoning amendments. So we've started to receive business license applications. We're going to set the ones aside that would be dealt with through this zoning amendment. We're hoping that this is dealt with expeditiously so that we can issue those business licenses for, for example, yoga studios. So it does mean that we will not be able to issue those business licenses before January 1st, but that will, to be clear to council and the public, that will not impact the operation of those businesses.
Well, that's good to know. Well, I have one final point to make. I think we decided, when we passed the zoning bylaw, we looked at the home business section in depth. And at the time that we passed the zoning bylaw, I asked that in 6 months' time, we send a survey out to people, and that motion passed council, and we sent the survey out. We asked for everyone's feedback. I don't think that it's appropriate to ask for feedback and then not use it. So to say that we want to hear more from the public because we think maybe the survey didn't give us the right feed, I'm not sure how to interpret that. So I'm happy with the survey. I think that it was prudent of us to do that and check in with the public about the home-based businesses. And we certainly got a lot of feedback that people feel that home-based businesses are really important in Lantzville. And they are really important to this council. And it's important that we regulate them properly so that people can make a living and our community is prosperous. So I'm not necessarily against public hearings, but I think in this case, it's likely redundant.
Okay, Councillor Savage, and then.
And one
yeah,
last
here in your-
amendment, I move that we have a public hearing for this zoning bylaw amendment.
So I think through to you, Councillor Savage, it might just be simpler to strike the last part of the motion, because a public hearing has to occur after first and second reading if approved by council.
Yes, I move that we waive the public hearing.
And through to Director Coates, does that make sense?
Well, it would be the usual, the motion. It's a motion to amend the motion on the floor
Yeah.
by striking, quote, and further that the district waive the holding of the public hearing, blah, 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 through to 2021. Yeah.
Okay, I'll second that. Through to Councillor Savage as the mover, if there's anything new to
Yeah,
add.
nothing much more to say, but as I say, it all comes down to respect of residents. I talked to two of the residents there at the door and they had no idea. They didn't have any idea this was happening. And that will be true of most residents who don't read council agendas every 2 weeks. So it's in fairness to them. And on top of that, they should be properly notified over such a major rezoning as the Blackjack property. So it's just showing respect to residents. There's no need to waive the public hearing on this. Thank you.
Okay, have you down, Councillor Wilson, but I will speak to it next as a seconder. Not much really to add. I just think a public hearing is in order. It's that simple. Why change process now? I do understand, in terms of waiving a public hearing, and there's been talk about that in larger municipalities or cities when it comes to some of these zoning amendments and so forth. But I see us as being a very small municipality, and this is something that I think residents would probably, if they feel strongly to object to, would like to have that opportunity perhaps at a public hearing. So again, I'm hung up on a couple items in there, but I would, my preference would be to hear from residents. I'm, for instance, I'm in strong disagreement with the 0.8 hectare for automotive repair. I see it as being no different than fine woodworking, metalwork, and so forth. I listen to at least a fine woodworking place, and I'd say that it's far noisier than most automotive shops I've ever been into. So, but again, I'm not going to keep going on and on about that. So through to Councillor Wilson.
We've been going on
go
this
ahead.
for a long time, but what I've heard from this entire debate and reading these letters that have come in, we're not talking about upzoning this property from 9 to 65 units. We're simply calling it a mobile home park. And regardless of whether, as it has been for years before there was any zoning. So I sit here and I listened to staff and I've read the report and I read the letters, and I think that due to some of, I'm not going to call it people being misled, I think it was just more of a mistake to think that immediately upon striking this, naming it as a mobile home park, that we'd be all of a sudden seeing 65 mobile homes there. That's not what's happening. I think that this, to me, was a fairly simple motion, and we've beat it to death. It's going to be at 9 after this. It's been a mobile home park for, like I said, for years.
And through to Councillor Wilson, the amendment right now is whether or not to hold a public hearing.
Well, I don't see that being necessary, given that we're not going to be seeing 65 mobile homes there tomorrow. And it's been a mobile home park for years, and there's 9 units there. If they want to make it 10, they got to come before council. So I won't be supporting that amendment. And I think we've wasted way too much time on something that was fairly simple. I'll leave it at that.
So I have Councillor Proctor and then Councillor Gusselbrock.
I have a question through you to staff. I'm not very familiar with automotive repair shops. I understand what goes on in a woodwork shop because a lot of that goes on in my house. But woodwork shops don't produce noxious chemicals or have noxious ingredients to get rid of. I think in an automotive shop, there are noxious chemicals that need to be disposed of properly. Is that true, Director Young?
Before I answer that, through the mayor to Councillor Proctor, I just wanted to clarify that the question was in relation to the amendment that's on the floor.
Yeah. So we are really dealing with whether or not it's a public hearing. If you want to further amend the motion afterwards and have further debate with respect to automotive shops versus other things, and we can.
Well, I think I think the answer to this question is, in my mind, is going to inform my decision on if we need a public hearing or not.
Okay, if that's going to help you determine whether or not to have a public hearing, Director Young, if you wish to weigh in, go ahead.
Yeah, through the mayor to Councillor Proctor, my apologies. Could you please repeat the question?
Do automotive repair shops generally have noxious chemicals that they need to dispose of properly? Are there environmental concerns that could be produced in an automotive shop?
Yes.
Thank you.
This is a point of clarification, automotive shop meaning like an industrial shop or a home-based shop? Because I know I have plenty of noxious chemicals and such in my garage, but just throwing that out there, I don't know if the scale is important or not.
Is that, Mr. Mayor, is that question for me or Councillor Proctor?
Well, I'm just wondering, like, it was your answer in relation to an actual automotive shop or in relation to a home base, like one person mechanic show?
Yeah, well, both would be considered automotive shops, whether it's in somebody's garage or detached building on their residential property or in a light industrial zone. But when you compare it with what would normally be associated with sort of just normal residential use, yes, we all have noxious chemicals and hazardous materials in our garages. I think that's true of most of us, just normal residential products, pesticides, gasoline, oil, those types of things. But the reality is, if it's an automotive shop, whether it's a small scale shop on a residential property or a larger scale shop in a light industrial zone, then it's going to be more intensive. If you're comparing those two, absolutely, a larger shop is going to be both of those things. Noxious chemicals and hazardous materials are going to be more prevalent and more intensive on those larger automotive repair shops in light industrial zone areas.
For that, Councillor Breck.
Yeah, automotive shops, you take batteries out and batteries are recycled. Canadian Tire, when you pick up a new one, they're generally recycled at a facility. You change the oil in a car, the oil can be recycled at a proper facility. As for noxious chemicals, compared to the wasp poison that I've got to use on Nest every once in a while, I don't think there's anything in an automotive shop that you would consider noxious. And I think, as the mayor pointed out, all of us have noxious chemicals, cleaning chemicals, et cetera, probably far more than we should have. But in terms of a automotive repair, it's pretty benign. I mean, Midas muffler, you get rid of the muffler, they have to recycle it someplace. Right now, I mean, it seems to me that everything is recycled. So I don't see that as a concern, and certainly not a concern to go to a public meeting when, as Councillor Proctor said, this survey, I mean, how many pages did we read? I mean, a lot of them. A lot of people weighed in. There's the public consultation. Council voted on that. We sent the survey out. We've gotten responses, and in response to the responses, this motion has come forward. So, unless somebody take me to task, I would, that we've been going at this since 6:45. It's now 8:15 or nearly 8:15. I think we've just given a lot of attention to all of these concerns, and I would move that the question be asked.
Okay, so I'm just going to be calling questions. So basically calling question on bylaw number 290.
The amendment.
Well, this would be as amended. So we're to the main motion as amended. Is that correct?
No.
Oh, sorry.
It's
Yeah,
amendment.
yeah, you're absolutely correct. Yes, it is the amendment to
By
strike.
striking and
Yeah.
further that the
All right.
district
So all
waive
those
the
in
holding.
favor of the amendment, and opposed, noting that Councillor Wilson, Councillor Gilsbrecht, and Councillor Proctor opposed, the amendment fails. Now we're back to the main motion as amended. So I'm going to call the question on that. So all those in favor and opposed, noting that Mayor Swain's opposed and Councillor Savage is opposed, that carries. So it takes us on to item 9D of our agenda. So bylaw number 291. So that the District of Lantzville accepts the resolution from the Board of Trustees for School District 68, Nanaimo Ladysmith, respecting proposed eligible school site requirements for the school district. So we'll take the motions separately. So do I have a seconder to that? Second by Councillor Gusselbrecht. I think this one's pretty straightforward, but is there any debate, questions for staff? I don't know if, I think it's pretty straightforward. I don't know if Director Young, if there's really anything to add or introduce us with.
And nothing to add, Mr. Mayor.
Okay, thank you. All right, so I'm going to move to calling question on it. All those in favor, opposed? Okay, that's carried unanimously. So that takes us to the next one, that the District of Lantzville School Site Acquisition Charges Bylaw number 291, 2021 be given first, second, and third reading. Do we have a seconder to that? Second by Councillor Gusselbrecht. Discussion on this, I'll lead it off. It's pretty straightforward. And I'm assuming this would be for all new applications once the bylaw is developed that this charge would apply to. So anything in stream, this does not apply to. Is that correct, Director Young?
That's correct. In-stream applications would have a 1-year protection.
Yeah. Okay, thank you for that. Just so everybody's clear on that. But yeah, I think this is great. The only other question I really have through to staff is, has a site, well, you probably know the answer to this already, but is a site being selected or for the District of Lantzville, like for a new school?
Mr. Mayor, no sites have been selected at this point.
Okay. Besides likely Upper Lantzville. So that's from what I understand. Okay, so through the rest of council, Council Gusselbreck, if you as a seconder, and then I'll open it up to the rest of council.
Nothing, thank you.
Okay, through the rest of council. Okay, hearing none, I'm going to move to call in the question. All those in favor, opposed, that's carried unanimously. All right, that takes us on to development variance permit application for 7452 Lantzville Road. I'll read the motion that the development variance permit number DVP 21-3 for 7452 Lantzville Road be issued to Mark Manfred and Dina Manfred. Do I have a seconder? Second by Councillor Savage. Discussion on the motion through to, I'm fine. So through to Councillor Savage, is there anything from you?
Yes, I certainly support this. No problem at all with it. Thank you.
Okay, and through the rest of the council? Okay, hearing nothing, I will call the question. All those in favor, opposed, that's carried unanimously. That takes us on to development variance permit application for 6976 Dickinson Road. That development variance permit number DVP 21-4 for 6979 Dickinson Road be issued to Ty Ding. Sorry, seconded by Councillor Savage. Discussion on the motion. For myself, it seems pretty straightforward. I have nothing to add. Through to you, Councillor Savage.
Yes, just again, I fully support it, and I take note that we did receive a letter from Mr. Guy, a neighbor. He fully supports it too. Thank you.
Okay, any further discussion through the rest of the council? Okay, hearing or seeing none, I will call the question. All those in favor, opposed, that's carried unanimously. That takes us on to item 10 of our agenda, unfinished business. So we have the Sunbury road name change request. And that the name of, so the motion is that the name of Sunbury Road remains unchanged. Is there a seconder for that? There's no seconder? Oh, you're seconding? Okay. Do I have a seconder for this? Okay, hearing none. Due to the lack of seconder, it fails. Councillor Gusselbreck?
I have a motion that the name of Sunbury Road be changed. Gotta be careful here because it's what side of Sunbury Road. So let me ask a question through the chair to staff first.
So, go ahead. Well, I was just going to suggest, are you looking at page 102, alternate number 1?
Let's look at that one. Where's the alternative?
So if you go
Page-
down.
Page
middle of
102?
Yeah, 102 of the agenda.
Yeah, I see the alternative on page 102, but I'm still not sure that's the answer to the problem. So I'd like to ask a question through the chair to staff. I don't think putting west or east or denoting Sunbury Road west or east is going to help a lot. I think there'll still be confusion. And I'm trying to remember the residents who weighed in on this were fairly passionate about it. So through to staff, if we change the name of either west or east, which side would it be the least problem? Or rather which residents would be the least inconvenienced by changing their road name? Would it be on the west side, which is the stub road, I'll call, or on the east side, which is a continuation of Sunbury where it comes off of Peterson?
Yeah, through the mayor to Councilor Gasselbrock. And thank you for the question. I think that my staff report caused some confusion. Staff were not recommending that east or west names be applied to Sunbury Road. We were simply using that to describe which section or segment of Sunbury Road we were talking about in the staff report. So it's just for reference purposes. But to be clear, there was no proposal to, rename it's Sunbury Road East and Sunbury Road West, although we do have those similar designations for other roads in Lantzville, like Harvey Road. But that's not what we were proposing. I would suggest that the change that would result in the least inconvenience would be to rename the section of Sunbury Road off of Hall Road, the short little segment, simply on the basis that all of those property owners are the ones who have expressed the concern and have requested a road name change. The property owners on the other section of Sunbury Road off of Sabrina Place have not requested a change. And so in staff's view, would be unfair to penalize those property owners. But to be crystal clear, we just want to make sure that council know that changing the name of any section of Sunbury Road will not result in a change in Google Maps and will not result in a change for these property owners. So council's fully entitled to change the name of any section of road in Lantzville, but we just want to make council aware of the fact that it won't actually result in a change in Google.
Well, I'm sure. So to be absolutely clear, the section that is off of Hall Road is the western section of Sunbury Road?
That's right.
Okay. Well, I think from the passion I saw from the residents there on the west section that they'll be able to handle Google. But be that as it may, I would like to propose that the western section, the westernmost section of Sunbury Road, let me put this correctly, that the name of the westernmost section of Sunbury Road be changed and that a name be selected from the list of names held by the Lantzville Historical Society. So if I want to repeat that the name of the westernmost section of Sunbury Road be changed and a name selected from the list of names held by the Lantzville Historical Society.
Okay, Director Coates.
Maybe Director Young could speak to it, but I understand that the alternative motion identifies that you're not approving it by a resolution. You're giving instruction to staff to bring forward a road name change bylaw to rename the west segment of Sunbury Road brackets off of Hall Road. So that a road name change bylaw to rename the west segment of Sunbury Road brackets off of Hall Road brackets be brought forward to council for consideration of, if you want to add, of renaming the road using the list of road names in the road naming policy.
Is that, and that's the policy taken from the Lantzville Historical Society?
I think the policy refers to the list, doesn't it, Director Young?
That's right. It's a council policy. It refers to the list and staff have that list on file.
So the change, the wording suggested by Director Coates, I agree with, and following what's in our agenda, where it reads to forward to council for consideration based on the list of names in the road naming policy.
So I think, if I may, through to Councillor Gusselbreck, I think alternative motion number one would achieve what you want it to achieve. Because staff will bring back everything you're asking. And all we have to put in there is West Sunbury, correct?
Yes, the westernmost section of Sunbury.
Yes.
So
The
through the
west
council,
segment of Sunbury Road, and then I've got in brackets off of Hall Road brackets for clarity.
and I would bring the name change bylaw back to
Yeah, no,
council.
that's, I think that's appropriate. We'll
Yeah.
get another chance to kick
Alright.
this can.
All right, so through to council, so that is that you're okay with moving that, Councillor Gusselbreck?
Yes.
Okay, I'll second that. And so as long as council is aware, page 102, alternative number one. Okay, and it is in the,
As a point of privilege, could you read that, please?
okay, so that a road change name bylaw to rename the west Sunbury segment of Sunbury Road, or I guess it would just be the west segment of Sunbury Road, be brought forward to council for consideration. Yeah. All right, so that's moved and seconded. Any further discussion on this item? So Councillor Savage.
Yes, I'll certainly support this, and this is the understanding, obviously, the residents affected will be consulted to make sure they support this, and I'm glad now that it's a name that can be achieved within the road naming policy, because that allows for geographical or flora and fauna items in the area could be named after, or if 100 signatures, I believe it's 100, are received from residents in support of a name, that can be considered as well. And of course, the great list by the Historical Society too.
Okay.
So I'll certainly be supporting it. Thank you.
Just real brief comment on it. Having lived living on a street where it's gone through all that name changing. So it used to be Voss Place and then Seaside Terrace. It took a while for the technology to catch up, but it's finally, I think, at a point now where if you Google Seaside Terrace, it actually shows up and you don't get any confusion or anything, but it took a while, and maybe today's technology will be a little bit faster to react to this name change. But I think it's in the staff report, it's not necessarily going to remedy the how to find their address any easier anytime soon. So, but again, maybe technology will be faster nowadays than what it was in the last decade.
And Moonberry might be a nice name.
Yeah. Okay, so I'm going to call the question. Oh, Councillor Proctor, I see your hands up. Go ahead.
Thank you. I just wanted to say that I'm happy to support this motion. We heard from all the residents on Sunbury West that they wanted this name change to take place, and I'm happy to accommodate their wishes.
So I will move to call in the question. All those in favor? Opposed? That's carried unanimously. All right, so that takes us on to, what do we got here? Losing my place. So under new business, mayor and council verbal updates, I guess I'll just lead it off real quick. So again, honored to lay the wreath on behalf of District of Lantzville that this year's Remembrance Day ceremony was actually fairly well attended, given the COVID restrictions and so forth. But again, it was a really well done ceremony and so forth. And it's again, it's we're getting closer to getting back to normal, and it was definitely much way better attendance this year than last year, of course. But again, it was really well done and put on by the Legion, of course, and it was really nice to see some of the veterans out there, and young and old. So I guess we'll go through Councillor Gusselbreck and then around the horn.
Thank you. I'd be remiss if I didn't note the beautiful voice of your daughter singing once again at this ceremony. It's a pleasure to hear her, and it helps the rest of us get on tune, especially. So make sure you thank her on behalf of us. I want to recognize our Public Works crew who came all hands on deck Monday during that storm They were out there at 4 a.m. in the morning, checking culverts, checking for damage. They were working again today, repairing a head wall on Andrea Crescent. They're fortunately, Lantzville missed the bullet. Unlike, our poor neighbors in the interior and the lower mainland who are still suffering mightily from this storm. But the Public Works crew should be commended for duty beyond the call of service. They've been out there working hard. I'd also like to thank Mr. Brian Blood for his series of pictures, his investigative reporting at the waterfront. And I was happy to hear that the culverts worked and the water drained, a couple of little hiccups. But I thought the pictures and the report was well done, and he should be thanked for it.
Okay, through to Councillor Wilson
Had nothing to add. Thanks.
and through to Councillor Proctor
I don't have a report this week.
and Councillor Savage.
Yeah, thank you. Yeah, it's because of this heavy rain event. It really was a rare event, one of the heaviest ones we've had. It really is important to point out it was a test for our drainage infrastructure. And so I think a real congratulations to Public Works over the many years is in order, because this is developed over many years. It's been done with a light amount of staff and a light budget. And one of the best examples of this is the Norston Creek flood diversion infrastructure that goes under Ben Walden Road. And without it, there would have been a lot of flooding. I'm quite sure it was just absolutely gushing out at high velocity onto the beach, this water. So I think that our whole drainage system in Lantzville has passed the test. There was no road closures that I heard of. There was no houses flooding that I've heard of. And you don't have to go far to see how much better we fared than a lot of other communities just here on the island, from Chemainus Roads to an apartment in Duncan was evacuated as a precaution and so on, Saanich, etc. So it really is a good testament. And if there were a few quirks, well, we now know, and they can be addressed in terms of making them better for the next one. And it's also important to know that the green space and forests are a part of our infrastructure, and they're very important for absorbing and holding water and dealing with it. So they're valuable. That's why green space and forests are so important. And of note, Copley Park was full of water, but that's good because it didn't go in homes. It was properly designed, so all the drainage comes away from the homes. And a big thank you is also deserved for residents once again helping each other. Sean Marston, for example, offered to help for free anyone needing emergency mini excavating work to alleviate flooding problems. And just the week before, Stan Potty for free addressed the fallen tree blocking the church entrance and cleaned it up. So community spirit is alive and well. Thank you.
All right, so those are our updates. Moving on to 12B, so municipal water service. So there's a notice of motion that was given at the November 3rd meeting from Councillor Wilson. So through to Councillor Wilson.
That staff prepare and send a letter to residents of the Winds, Blackjack Drive, Clark Drive, and Alger Road areas, updating residents on the progress regarding water.
Okay, and do we have a seconder to that? Second by Councillor Gesselbrack. Discussion on the motion. So through you, Councillor Wilson.
No, I just think this is a way just to communicate to residents, and I just think it's something that would suffice as far as what we discussed at the last council meeting, as far as getting the information out.
Okay, and through to Councillor Gusselbreck as the seconder.
Nothing to add.
Okay, and through the rest of the council. So I see Director Coates.
Yes, at the last meeting, there was some discussion about the option of the district distributing the information via the newsletter. And staff, it would be remiss if we didn't bring that up as an option. When we do send out letters, it's a costly undertaking. As well, when it's for specific segments of the community, we have to do some research and get the addresses. And then there's the postage that's $1 something a letter. So before we know it, it's double or triple the cost of putting out a newsletter.
Okay, so Councillor Gusselbreck.
I note that, and this is through the chair to staff, I note that the normal format for our monthly newsletter is 4 pages, 2 pages fold out. Could a supplement be put in there?
So the answer to that was no from Director Coates.
No, but we could dedicate a full page, which would probably be the same size as a letter.
Well, that was my question. Can we
No.
put an insert or whatever you want to call it that would address
Yeah.
these people as
Yeah.
well and contain this information?
And sorry if I misunderstood. I thought you were asking about putting an insert inside of the newsletter, which we cannot do. But we can, dedicate the full back page to this information if you wish.
It's up to Councillor Wilson if he thought that might have merit.
Yeah, I think if you dedicated 1 page, it would be the same as sending out a letter. Dedicate the back page to the update regarding water and save some money.
So through to council, how would you want to amend the motion on the floor? Is it simply just to prepare an update for residents on the progress of water to be included in a future District of Lantzville community update? I think that would probably work. So through to council, just by unanimous consent, does that work? So essentially we'd be just taking the last portion of the motion, updating residents on the progress of water or progress regarding water to be included in a future District of Lantzville community update newsletter. Okay.
So I've just got the
Unless
staff.
anybody strongly objects or objects, we
Yeah,
can just use that.
staff prepare and send an update to residents of the Winds Jack. Well, I guess you don't have to
That's what I
name
mean.
all
It's
the
just a
areas, do
community,
you?
right? It's
Yeah.
just goes to the community. But obviously the focus is going to be on the unserviced areas.
Mhm.
Okay, so I don't see any objections. Councillor Savage and then Councillor Proctor.
Yes, thank you. That should do it, and it won't cost anything more, so that's fine. I still would prefer to have had the to and fro because, there'll be questions, they'll be asked, and you get more clarity that way. But I think it would be a good idea. They do get an update as what's being done, what they can expect, and so on for updates. And I did ask about water to a couple of the residents that I saw in Blackjack, and they indicated they have good water, but entertained the possibility of supporting it. And they did reiterate there's people down that end of Blackjack that have been waiting a long time that do not have good water. So I think this will be good. They can hear after these years as to what's been going on and what they can expect. So thank you.
Okay, Councillor Proctor.
I can support this. I think that the more information we get to the community, the better. And I actually prefer that it goes out in the community update, because I think that people that don't live in those areas are wondering about the water situation, and everyone needs to be educated on what steps we've taken and what sort of future remedies we could look at. I think that it would benefit the whole community to receive that information. I see a lot of misinformation about water on social media. So I would like to see it clarified. And also through you to staff, would you be indicating in this update who people could direct their questions to if they had some back and forth type questions about the information presented?
Yes, yeah, we usually have contact information, yes.
Great, thank you.
So I'm gonna move to calling the question unless there's something new. Okay, hearing or seeing none, nothing, I will call the question. All those in favor, opposed, it's carried unanimously. That takes us on to bylaw number 160. Councillor Savage, you have a recommendation on the agenda, so if you wish, you can make your motion.
Yes, I move that election and assent bylaw number 160 be amended by adding after 9.1E, 9.1F. If a manual hand count of ballots is requested by any candidate for mayor or council, a manual hand count of ballots must be performed in the presence of that candidate to confirm the results of the election.
Okay, I'll second that for discussion because this might be a little interesting, but go ahead, Councillor Savage.
Yes, thank you. This is a simple housekeeping item, which is necessary to ensure residents can be confident in our election results every 4 years. This has become necessary due to the widespread fraud and perception of fraud that's just permeated around the world, actually, in the past few years. And it's been trending and increasing worldwide. So the confidence in voting machines has declined. Lantzville is small enough that hand counts certainly are not onerous. About 1,400 ballots are often cast in Lantzville elections. And this motion only applies to the 5 positions of mayor and 4 councillors and not to other positions on the ballot like the school board. So it's for confidence reasons, and it has happened in the past. There's been hand recounts, but generally it's been when it's so close that it has to be within a certain closeness. So I'm just broadening this so that there's no, I just want every election to lead to acceptance of the results. It doesn't mean there's going to be hand counts requested. It just means that if they are, then it's done to confirm the results. And by just having that option gives confidence. So that's generally what it is. Thank you.
The seconder, I just had a brief question through to staff or through to Director Coates. Is there a mechanism already in place if a candidate was to request a recount for that to happen, or is this?
Yes,
Okay. And
there's already a very large section in the Local Government Act to request a judicial recount. I think, though, what they would find is that the court would likely use machines for the recount. So, you know, and I'm certainly the last one to question the court or decisions they've made, but there's been several rulings by the court in relation to votes, elections that were held using voting machines, and then someone has challenged the election and then wanted the recount to be done manually. But it's really the court who does the recount. I've participated in that when I was in Squamish, participated in the one in Whistler, and the court makes the decision, but then they oversee it. So we were there as staff on behalf of Whistler to run the ballots through the machines.
Okay, thank you. And just as a follow-up, is the candidate who is requesting or challenging the process allowed to be present for the recount?
Yes, yes, absolutely.
Okay.
That actually there's more than the candidate, you know, a citizen could apply. The chief election officer could apply. That's rare. I've seen it happen when there's been a tie vote. And that was, yeah, I think, and our CEO certainly has knowledge of one that was held with the District of Hope that went through the court process. And the court, it said the court considered the grounds on which a recount is available under Section 138 of the Local Government Act and concluded that the legislation did not permit a recount in these circumstances, simply the fact that it was a voting machine election. And the court noted that the district was permitted by bylaw to authorize the use of voting machines. And if the legislature had wished to permit recounts when voting machines indicated close results, it would have done so. So that's me quoting from the ruling from the court. And I did check with the ministry. They felt it was redundant to suggest adding that.
So just as a, I guess, a clarification then, so the only, like at this point, the only method a candidate or a resident has is they would have to file a court action to have a recount? Or
Well,
can they come directly to the municipality and say, I'm challenging the results and I would like a manual recount or an electronic recount?
yeah, there is a process. It says an application may be made in accordance with this section. It's in the Local Government Act. And it's usually that they feel the votes weren't correctly accepted or ballots weren't counted correctly or it wasn't accurate. And it can be made by an elector of the municipality, a candidate in the election or a candidate representative or the chief election officer. And there's a form, it's just an application form that the province provides and they submit it.
And that application would go to the chief election officer?
I believe it would go to the court. We provide them.
Oh, so it'd go to the court. So
Yeah.
I guess I'm sorry, I'm rambling on, but I'm just trying to understand process and, you know,
Yeah.
how cumbersome it is for the individual to make a challenge. Like, is there costs associated with it? Do they have to get a lawyer? Like,
I didn't see any lawyers, the one I was at, but, you know, I've got the form here. If somebody wanted to look at it.
so they submit it to court and,
Yeah.
okay,
And the court has a very tight timeline in which to do the recount. And so it's all very detailed and laid out. And I should have backed that up with, just for clarity too, there's you know, the council adopts the bylaw that says you're going to have, you know, you're going to use voting machines. And I understand Lantzville's had those since they were incorporated. Certainly, I know they were in place before I came here. They've been used around the province for 30 years. And while I acknowledge that, yes, there's been some media around the world about the perception of fraud, we refer to it as the Trump effect. And I don't think it does us well to in any way reinforce the myth. There's been several court cases, recounts, processes, and the machines have always been held to be very accurate. In fact, I've been doing elections and I've done the manual elections. I recognize what that process looks like. Even when, you know, as a chief election officer, you have to do the final determination. And so that piece is not something we as chief election officers can then delegate to a candidate. We're responsible once the election is held. The preliminary results are released on that Saturday night. We schedule the final determination usually for the Monday. We have to declare the election by the Wednesday. And so it's up to us to then go through and look at things and determine, you know, if there's a ballot account, we want to double check or if there's anything. And certainly we have a duty to apply to the court ourselves if we think there's something untoward. But it's very, very clear. It says that, you know, we notify the candidates, and we've got that on our calendar already, that the final determination's on the Monday after the election. And candidates can attend and they can observe and see what we're doing there as I go through the process of verifying the results. And then once I've declared, then that's their opportunity to then go and, you know,
Okay.
make a decision.
All right, thank you for all that. Councillor Wilson, I do recognize you did have your hand up earlier. Did you have a question or?
You actually pretty much answered or asked a lot of the questions I was going to ask. I seem to remember when we ran or campaigned 4 years ago, I did look up that there was a mechanism for this already in place. Yeah, I won't be supporting this.
Okay. Councillor Gusselbrook?
Yeah, thank you. Yeah, I can't support this motion for the same reason. We have a very fulsome mechanism in place for not only vote counting, verifying the votes as they're being counted, but also a procedure for a recount. And I wasn't aware that there is any lack of confidence in the District of Lantzville in vote counting. There's certainly candidates who are disappointed when they don't win, but that's not a reason to have a lack of confidence in the counting. The legislative framework is that the Local Government Act says that municipalities can create an election bylaw. And in fact, we have an election bylaw, number 160/218, which was passed in 218. You can look on the website to read it, but it goes through all the steps on memory cards, voting counting units, et cetera. And from my reading of the bylaw, as well as the Local Government Act, that during the counting, during the balloting process, a candidate can be present or candidates can be present during the balloting. And if a ballot is rejected by the chief election officer or a designate, that can be settled right there. And but the person objecting has to make his objection. It's not necessarily settled at that point, but the objection is noted. So what happens then is that under the under the Local Government Act, it says that on the 13th day after the results of the election are declared, a party, an aggrieved party, can apply to the court to have ballots recounted, a judicial recount procedure. And there's in the Local Government Act at section 149, it goes through how that's done. So it seems to me that at every step of the process, there are safeguards in place so that whether it's a challenged ballot or whether it's the counting of the ballots in the first instance or a recount before the court, we're more than protected. It's simply, we don't have a Dominion voting machine scandal here in Lantzville. So I won't be supporting this motion.
All right, any additional debate comments on this item? So Councillor Savage.
Yes, Lantzville has a bylaw, the election and assent bylaw number 160, and in it, it refers to recounts. So I'm simply broadening the ability for recount. We don't have to stand on the fact that it's a hand recount, but just a recount, and not having to go through courts and so on and so forth. That's all. I'm simply amending our bylaw, not involving courts and so on. And I've seen recounts here in Lantzville in the past. So as a generally when it's a close race. However, I'm just broadening it so that if any candidate requests it, a recount can be done with the apparatus we have here, the election apparatus. So that's all that I'm doing is doing the existing bylaw, not involving courts and all of that. So question through to staff, is that a possibility, Director Coates, within this bylaw, can we not simply expand right above this? It talks about, on that page, it talks about recount. So I'm just broadening the criteria for recount, that if anyone asks for one, and if it's not,
I recognize
process.
it sounds simple, but in fact, it's undermining the delegated authority of the chief election officer. So clause 9.1 says if a recount is required, it should be conducted under the direction of the chief election officer using the automated vote counting system. So I think the concern that the ministry had when I spoke with them was the thought of creating a new system where we hand that decision to a candidate to decide when and if a recount would happen. They felt there is detailed information in the Local Government Act about judicial recount.
Gotcha.
I think what perhaps the bylaw could be worded more clearly, that when it's talking about recount here, it's talking about the chief election officer doing their final determination before they make their declaration. It's common, that the chief election officer will, audit steps. And, but we get a lot of training, we get a lot of legal cases thrown at us of, best practices. And we have a manual that's produced by the Local Government Management Association. It's vetted by a group of our peers, chief election officers and lawyers, and the ministry gives input to it. And so it says manual versus automated counting process. If the vote counting was automated, the need for a recount on anything but a tie vote should be unnecessary. That's the word right out of the manual. So I think the description that's here is if, as chief election officer, during the final determination that the candidates attend and observe, if I chose to, I could run the ballots through again. That would be very rare. I think, some of the bylaws they evolve, over time. And yeah, I'm not sure that this one even needs to be described the way it is in here.
yeah, and in there, what is the reference to recounting? What's the criteria for it? I don't have the bylaw with me. I was away today.
So it says okay. It's called, in the manual, they call it an informal recount. Whether to conduct an informal recount or not is strictly at the chief election officer's discretion. Some candidates might strongly encourage an informal recount when the vote is close. Chief election officer is the best judge of whether a recount should be done. However, there is no obligation to conduct an informal recount or to apply for a judicial recount unless there is a tie vote for two or more candidates, in which case the chief election officer must apply for a judicial recount.
Yeah,
But
but in our bylaw, what does it say? Sorry, I don't have it here. I remember
got
it
it here.
said something about recounting. Yeah.
It says, it just says if a recount is required, it shall be conducted under the direction of the chief election officer. And then it talks about the process. And then it says in the event of a tie vote after a judicial recount, tie vote will be resolved by conducting a lot draw.
Right.
So
So,
that's, yeah.
so it would be up to you to entertain one if it was requested by a candidate then.
No,
Sorry?
no, I would not. I would not do that. I'm not creating a system that supersedes the Local Government Act. The Local Government Act provides a process for citizens and candidates and myself as chief election officer to apply for a recount. I have a duty, to go through, like, a lot of that wording is designed for a place that has more than one voting place and presiding election officials. And because we are small and we have one voting place, in effect, I am the presiding election official and the chief election officer. So, but I still go through that process of have, the deputy sign off on the Saturday night numbers and on the Monday, we're going through, we're reviewing it, we're auditing it. Candidates can be there and observe that. And then if I feel like there's something out of whack, I can go through and change numbers if I want to on the ballot accounts. Maybe somebody made a mistake adding, I'm not saying on the machine, I'm saying on the ballot accounts. And so, yeah, so that is the process. And then I also have the ability to apply to the court if
Yep.
I feel there should be a recount.
All right, thank you. Good information.
Lots of questions, lots of information. I did have one question, and I don't have the bylaw number 160 in front of me. So is there a reference in the bylaw that the process for the judicial review, like if a recount is requested, what is the next step? And is that to apply to the court? Or a reference to the Local Government Act?
Yeah,
or
we
something? I don't know.
usually repeat what's in the Local Government Act in the bylaw.
Oh,
It talks about in the event of a tie vote, applying. But certainly in the manual, the brochures provided by the province to candidates, and in our information, we include that in our education process, for the candidates, the orientation process.
Sorry to interrupt. I just, for me, as long as it's like the instructions are simply laid out
Yeah.
for both candidates and residents, that if a recount is requested, what is the next step?
Yeah.
And if and I can accept the next step being that you go to the court, you file your application for the
Mhm.
recount, and then it takes care of itself from there.
Yep.
So is it clearly, is the instruction fairly clear on if, from what we're putting out to residents and to candidates from the
I
district of
think
Lantzville?
that is more a process that goes into the public education piece. So I don't have it right here. I
Sure.
should pull it up, but there is a 4-page newsletter that goes out that's specifically about election.
Okay,
And I believe there's a piece on the close of it that talks about, what happens after the election.
Yeah.
And yeah,
and I understand the intent of Councillor Savage's motion here in the sense that, you don't have to go through a formal process to have a recount. However, there is a formal process, and it's to ensure that every municipality is following the same steps, and it's a tried and true process. So I think doing anything different at this point is probably not indicated. I think as long as residents and candidates alike are properly informed, I don't think it would be required. So for those reasons, I won't be supporting the motion. So any further debate, comments from council? Hearing or seeing none, I will move to calling the question. All those in favor and opposed, Mayor Swain, Councillor Kesselbrecht, Councillor Wilson, and Councillor Proctor opposed. The motion fails. Takes us on to the next one, which is 12D, which is, I'll just read the motion. And this comes from the Regional District and Nanaimo, requesting consent for Regional District and Nanaimo Regional Parks and Trails Service Area Amendment Bylaw number 1231.08/2021. So I'll read the motion that the Council of the District of Lantzville consents on behalf of the electors to the Regional District of Nanaimo's board adoption of Regional District and Nanaimo Regional Parks and Trails Service Area Amendment Bylaw number 1231.08/2021. And further that the Regional District of Nanaimo be notified accordingly. Do we have a seconder to that? Second by Councillor Savage. Discussion on the motion. Okay, for myself, I think it's pretty straightforward. It's just this is just something the RDN has decided to do to make sure that the costs are fairly apportioned to the participating members of the RDN when it comes to the Regional Parks and Trails Service. So I don't know if I see Director Harry, you're on the call this evening. I don't know if there's anything further, as this is more of a financial motion to add or introduce.
Sorry, can you repeat that? I had just stepped away for a moment, Your
So we're
Worship.
just on item 12D. And this is the RDN motion with respect to the Parks and Trails Service Area Amendment bylaw.
Mhm.
Yeah, I just didn't know if there's anything from the District of Lantzville Financial Services Department with respect to comment on this before I open it to the rest of the council for comment, debate.
I don't have anything to
Okay.
comment at this point. Sorry.
No worries, Ed, you don't have to apologize. Through to Councillor Savage, go ahead.
Yes, thank you. I'll certainly be supporting this. I have such confidence in our regional district with parks and trails going back, 25 years. They made it a point of accumulating land and trails. And it was a continuous, consistent effort over many years. And just look at all that they've accomplished. They've just got beautiful parks and trails throughout. It was always well run, thoughtful, always with best bang for the buck in mind. And boy, I'm glad it was moved ahead on the land prices are far in exceeding what they were back then over the many years. So I'm thinking they're making all the right moves with parks and trails. We all enjoy them, all take advantage of them. So I fully support that we're all paying equally into them. Thank you.
And I just had a real brief follow-up comment. So on page 121, on table 2, if you look at the change in allocation, I believe Lantzville ends up paying a little bit more. So this would be, this is part of the whole argument is each member municipality or electoral area paying their fair share or equal share when it comes to parks and trails and the regional district in Nanaimo. So anyways, just pointing that out. Through the rest of the council, any further debate, comment before I call a question? Okay, hearing none, I will move to calling the question. All those in favor? Opposed? That's carried unanimously. That takes us on to introduction of late items. Any late items to be introduced? Okay, hearing or seeing none, we'll move on to notices of motion. Any notices of motion? And we don't have public clarification, so that just means we got through our agenda. I declare the meeting adjourned.